Good afternoon, everyone. Welcome to the House Judiciary Committee's Day of Bill Hearings. Today is Thursday, February 10th. Chair Clippinger is momentarily in another committee and he'll be with us shortly, but we're going to go ahead and get started. Members, please set yourselves to mute and only unmute when I recognize you to ask a question. After a witness testifies, you may ask questions by selecting the raise hand feature on your Zoom window, and I will recognize members in the order they raised their hands. Witnesses, you will unmute yourselves when I recognize you to present your testimony. After you present your testimony and answer any questions from the committee, please exit the Zoom hearing room. At all times, members of the public will be able to view the live stream of this meeting. The live stream is accessible on the Maryland General Assembly's website. Per our 2022 witness guidelines, two of today's scheduled bills are reintroduced bills, and so they are on the 2-1 rule, 2 minutes for the sponsor and 1 minute for witnesses. Those bills are House Bill 360 and House Bill 459. All other bills are new and will operate on the 3-2 rule, meaning 3 minutes for the sponsor and 2 minutes for the witnesses. The order of bills today is going to be House Bill 452, Delegate Kerr, House Bill 360, Valentino Smith, House Bill 446, Delegate Forbes, House Bill 369, Delegate Belcastro, House Bill 338, Delegate Lopez, House Bill 294, Delegate Crutchfield, and House Bill 459, the chair's bill. So we will go ahead and get started with House Bill 452 from Delegate Kerr. And it looks like it is just our friend, the delegate, who will be testifying today for 3 minutes. Go ahead when you're ready.
Thank you, Mr. Chairman. Good afternoon, members of the Judiciary Committee. I'm Delegate Ken Kerr, here before you today to present House Bill 425, Frederick County Disposition of Marriage Ceremony Fee. Genealogy is the second most popular hobby after gardening, and genealogy searches are the second most visited category of website on the internet. One of the most common types of record search for is the marriage certificate. In 2015, I spent a month in Belfast, Northern Ireland doing family genealogy research, and my most fascinating find in the Public Records Office was the 1849 marriage certificate of my great-great-grandparents. This led to me learning the names of my great-great-great-grandfathers, finding out my great-great-grandfather was a widow and that both he and his wife were illiterate as they signed their names with an X. It also led to my finding and visiting the farm where my great-grandfather was born 4 years later in Garvaghey Parish in County Down, all from one document, an 1849 marriage certificate. These records are important clues to a family's history, but only if they're curated. This proposed legislation would amend current law to direct a portion of the revenue from a marriage ceremony fee performed by the clerk of the circuit court to Heritage Frederick, the Historical Society of Frederick County. This would ensure that all revenue collected from this fee would come back to Frederick County. Heritage Frederick, like all heritage societies, is dedicated to preserving, collecting, and researching local artifacts. Many, like Heritage Frederick, have taken on the role of repositories and stewards of certain historical documents and records, marriage certificates among them, and the proposed fees from the collected civil ceremonies in the county redirected to Heritage Frederick would support the maintenance of this collection of marriage records. Currently in Frederick County, the fee for a civil ceremony performed by the clerk of the court is $25. The clerk pays $10 of that fee to the general fund. The remaining $15 is retained, deposited and dispersed in the same manner as other fees. 9 other counties, Allegheny, Anne Arundel, Baltimore, Cecil, Garrett, Montgomery, Prince George's, Hartford, and Washington, all redirect that $15 from the state back to their heritage organizations. This proposed legislation would add Frederick County to the counties that are able to do this. It also requires accountability by requiring Heritage Frederick to report annually to the county as how these funds were spent, and allows the county at any time to request an audit of the records. And I request your favorable report.
Thank you very much. Are there any questions for the sponsor? All right, and I think that's it. That'll wrap. Thank you. That'll wrap House Bill 52. Next, we're going to go to House Bill 440, House Bill 360, Delegate Valentino Smith. And let's see. Who signed up on that?
Don't start that clock yet. There's a panel. They'll come along.
Okay. Yeah, why don't you go ahead and
Thank
get
you.
started when you are ready. And that's a reintroduced bill. So it's on the 2-1 rule, 2 minutes for the sponsor, 1 minute for the witnesses. Thank you.
All right. Well, I didn't rehearse the 2 minutes, but I'll give it a try. I will say, good afternoon, Vice Chairman Moon. From my days in judiciary, miracles do happen. So I do believe in that now. Good afternoon, everybody. Look, you've got a long afternoon. You know a lot about juvenile justice reform. I've been working on the concept of informal adjustment, if you look at the fiscal note, since 2015. So I won't take all day. You're going to hear a lot about it. Finally, we've been working on the concept that there's a great opportunity to take youth before they're adjudicated and provide them with services, to provide them with an informal adjustment process. And if completed and successful, it doesn't go into the judiciary process. It fulfills the mission of our juvenile reform policy, which is rehabilitation, not punishment. And finally, in 2020, this committee passed House Bill 842 because in the evolution, we got to the point where the Office of Public Defender, the state's attorneys, and DJS all agreed, and your committee in its wisdom passed the bill. Unfortunately, we got cut short with COVID. We came back with this concept of informal adjustment, and the provisions of House Bill 842 that were passed and adopted were cited in the Juvenile Justice Reform Council's interim report as a crucial foundation for the process of informal adjustment. And last year, you passed provisions in that reform package only to have it come crashing down in the Senate. So for those that are new to the committee, the process of informal adjustment allows us to manage the cases that are unique to where the adolescent is. A few days ago, I met with the Office of Public Defender, the state's attorneys, and DJS in my office. We all agreed the priority of this is significant for our state and our juveniles. They should wait no longer. That the provisions in the Justice Reinvestment Bill that you'll be hearing at the end of the day are preferred. And those are the provisions that should be amended into my bill. And you'll hear testimony as to why. The standalone bill is here, as you know, as a vehicle. Let's not let this, did I hit 2 minutes?
Yeah.
All right. So let me conclude. You know why the standalone vehicle's here. This issue is too important to succumb to some final days if justice reinvestment in a complete package isn't going to pass. Let's get this over to the Senate in the fashion it should be in and not wait any longer. Thank you, Mr. Vice Chair. If the panel can go forward, that would be appreciated.
Thank you. And we've got 3 folks signed up to testify, 1 favorable and 2 favorable with amendment: Gavin Potashnik, Jenny Egan, and Betsy Tolentino. And we will take them in that order. It's 1 minute per witness. Gavin Potashnik, you can go when you're ready.
Mr. Vice Chair, members of the committee, Gavin Potashnik, Deputy State's Attorney for Harford County. I am in support, and the MSAA is in support of House Bill 360. And we thank Delegate Valentino Smith for her leadership on this. I want everyone to take a picture because for once, the Public Defender's Office, the MSAA, and the Department of Juvenile Services is all on the same page, and America has not fallen. This is a good bill for us to pass. I will note that in Harford County, this already happens, although by a loophole in the law, unfortunately, when a child is what they call remanded back to the Department of Juvenile Services, DJS has no authority to do anything, which is a complete and utter waste of that entire whole process. This bill legitimizes that, and I think it's important, and I ask for your support in passing it. Thank you.
Thanks. Next, we'll hear from Jenny Egan.
Thank you so much. I know that this committee may think it's historic that both Mr. Potashnik, Ms. Tolentino, and I agree, but actually this is something that this group has been working on for a long time to improve these services. We support with the amendment to make this mirror the language in the larger omnibus package, but it is so critical and important. What we know, there are benefits to diversion and informalization. It prevents kids from associating with more delinquent peers and getting pulled deeper into the system. It also helps hold youth accountable for their actions in a developmentally appropriate way by providing proportionate responses to their delinquent behavior. Providing youth to connect with opportunities and service in the community is what we all know works best. And for that reason, we support this bill very enthusiastically with that one minor amendment. We ask you to vote favorably.
Thanks. And last but not least, we've got Betsy Tolentino.
Good afternoon, everyone. My name is Betsy Fox Tolentino, and I'm the Deputy Secretary for Community Operations at Maryland's Department of Juvenile Services. And I first want to thank Delegate Valentino Smith for her many years of leadership on this incredibly important issue. What this bill does is just creates a pathway to intervene, support youth and their families at the earliest moments. We have many safeguards built in. If the agreement doesn't work out, if the supervision doesn't work out, if the intervention isn't appropriate, to be able to go back to the court to have the matter addressed more formally. But being able to intervene immediately gives young people the best chance for success. So we hope at the Department of Juvenile Services that you all support this initiative and pass this bill favorably. Thank you.
Great. Are there any questions for the sponsor or witnesses? As Delegate Cardin, go ahead.
Thank you. Just real quick, I love all this, the consensus here. If a victim, if everybody agrees, if the state's attorney agrees and the public defender agrees and the alleged perpetrator agrees and the family agrees and the court agrees that the victim is not in agreement, what happens?
Gavin, do you want to go ahead and let him know? It goes forward, but go ahead, Gavin.
Sure. So the way the bill is written, the victim doesn't have a direct pipeline to the court for their opinion. However, I will tell you, Delegate Cardin, that our office would not proceed with an agreement of this type unless we had some assurances from the victim that that was something that they wish to do. That's what we do in Harford County. We don't remand to Department of Juvenile Services under our structure unless we have that conversation with them. And I will tell you that I know juvenile is tough to explain, but oftentimes when we sit down and have that conversation with the victim, where we explain what we're doing and we explain what the benefit is, we explain everything that goes along with it, I would say 99.9% of the time the victim agrees with that disposition with respect to this. So I am not, that is not a deal killer for me. And I think that our offices and the MSAA can handle that type of traffic.
And in addition, Delegate Cardin, the recidivism rate is so low when you use something like this. In the end, you end up having many less victims for the state's attorneys to be working with when this process is in place.
All right. It looks like there are no additional questions, so that'll wrap the hearing on House Bill 360. Thank you, everybody.
Thank you,
And
Mr. Chair, Vice Chairman.
we'll now go to House Bill 446, Delegate Forbes, and there are two witnesses signed up, Brian Fisher and Ann Gerzon. Delegate, and this bill's on a 3-minute, 2-minute rule. So Delegate Forbes, 3 minutes when you're ready.
Thank you, Vice Chairman. Thank you, members of the Judiciary Committee. For the record, I'm Delegate Kathy Forbes, and I'm grateful for the opportunity to present to you HB 446. This bill will increase the amount of funding the Baltimore County Historical Trust receives from the performance of courthouse marriage ceremonies from $15 to $25. Some history on the issue. The National Historic Trust Preservation Act of 1996, a federal law, required states to protect historically significant buildings and invest in historic preservation. Instead of making this part of government operations in Maryland, we vested that responsibility in nonprofits. In Baltimore County, we have the Baltimore County Historical Trust, which does business as Preservation Alliance of Baltimore County. But here's the very unusual part, I thought, when I found it. The trust and other nonprofits across the state receive their funding through a Maryland family law statute, which is why I'm here in Judiciary today. It requires a portion of the proceeds from wedding ceremonies that are held in the courthouse, performed by a clerk or a judge, to be directed to these preservation groups. And for the Baltimore County Historical Trust, this is their main source of income. So across Maryland, with the exception of Cecil County, where it costs $30, it costs $25 to get married at the courthouse. And currently now in Baltimore County, $10 goes to the general fund and $15 goes to the Baltimore County Historical Trust. This bill will allow Baltimore County or the trust to receive all $25. And you should have a letter of support from Baltimore County, and I thank our county executive for supporting this bill. Baltimore County Historical Trust was struggling to do their work before the pandemic, but when courthouses closed, their income went to zero. They have never returned to their earlier funding. And so this 40% increase in the short term will help them move along. And when the courthouse ceremonies go back to normal, they will finally have a reasonable and sustainable level of funding. I ask for your support, and you'll hear from Ann, who is the executive director, the part-time employee at the Baltimore County Historical Trust, the Preservation Alliance. And I ask for a favorable report on HB 446. Thank you.
Thank you. Yes, and it looks like we don't have Brian Fisher today. So Ann, go ahead whenever you're ready. You have 2 minutes. You've got to unmute yourself.
That would help. Thank you. Thank you, Vice Chairman Moon. Appreciate that. And thank you very much to Delegate Forbes. We greatly appreciate all of her work, as well as the support of Executive Olszewski. Preservation Alliance of Baltimore County, we're also known as the Baltimore County Historical Trust. We just celebrated our 40-year anniversary, though we have, as an incorporated organization, nonprofit, but we've actually been around since the 1970s. And our main mission is preserving the historic buildings of Baltimore County, as well as landscapes and open space of our unique county resources. We're very grateful for this opportunity. Our goal, as stated, our mission again is to preserve our historic buildings. We work with local individuals, county residents, as well as county nonprofit organizations to help secure the preservation of the historic buildings and properties that they care greatly about. We provide direct preservation services. We help individuals with tax credits. We work with individual organizations and again, and citizens of the county to help restore buildings, financial incentives. We have a small grant program that we give to both other local nonprofits as well as to limited income. Right now, we're limiting our grant program to individuals, to limited income senior citizens. We just had our first grant round for that portion of the program to the East Towson Neighborhood Association, East Towson Neighborhood Improvement Association, working with some local seniors there to help make some needed repairs to their historic homes. As Delegate Forbes mentioned, our resources in terms of our financial resources have been greatly affected by the pandemic. There were several months where we received no support at all. Our finances in terms of our savings have pretty much dwindled. We were lucky to receive some grant funding, which we're again also very grateful for, but our financial situation has changed. I am the sole employee. I'm only part-time, and we only had a part-time executive director for close to 30 years. So we have a large county and a lot of area to cover. We'd like to be able to do more work with preserving our historic resources. Okay, thank you.
Yeah, you can wrap up.
Again, just wanted to thank the committee and again, Delegate Forbes, and we appreciate your support and supporting the historic buildings and properties of Baltimore County and the state of Maryland.
The chair might be here, but it looks like Delegate Cardin wants to ask a question. Go ahead.
Real quick, and just a point of, for the committee, we voted this out of subcommittee and delegation, and it will be on the voting list and be to you guys by next week. And this can be either for Ann or for Delegate Forbes, but our discussion earlier today, Delegate Forbes, was that the estimated amount of money we're talking about is not a significant amount. This is about $25,000 to $35,000 annually is what the increase would be, and that would barely basically sustain the nonprofit. Is that fair to say?
So yes, pre-pandemic, in a good year, the Baltimore County Historical Trust received $36,000 a year. Since, as I said, it went to zero during the pandemic, but since the courthouse is reopened, they're receiving about $24,000 a year. This would increase their funding by $24,000 a year. So they'll go from 36 to 60.
All right. Hi again. We'll go to Delegate Anderson, please.
Yeah, thank you, Mr. Chairman, and good afternoon, everyone. With regard to the Baltimore County Historical Trust, and we just had a bill from Frederick County, is there an umbrella group at all that deals with all the historical trusts in the state of Maryland? I know there's something called the Maryland Center for History and Culture, but I think that's probably different, right?
That is correct. The Center for History and Culture deals more with artifacts and genealogy and documents, which are of course also very important, but we deal with more physical, larger entities like buildings and landscapes. So things that the public will see on an everyday basis, whether they're walking in their neighborhoods, driving around the county. So we deal with the physical embodiment of history. So the things that the public will directly see in their everyday lives.
Okay, and is there an umbrella group for all the historical trusts across the state?
To an extent, there's an organization called Preservation Maryland, but we're all independent. We're all independent organizations. Some counties do have historic preservation organizations in the state of Maryland, but not all of the counties do. So it's not necessarily a direct umbrella group. It is a statewide group, but we do not report to them or anything of that nature. So we're separate entities, but we try to work together, of course, to preserve our historic buildings.
Okay, thank you. And I want to welcome Delegate Forbes prematurely to the 43rd District.
Thank you. I'm happy to be there.
Okay. Are there further questions for this panel? Seeing none, we thank you all very much for coming and testifying here today on House Bill 446. And I believe that's everybody. So that's just fine. That concludes the testimony on House Bill 446. We're going to go now to House Bill 369 and Delegate Belcastro. She is joined by several people, but we'll start with Rachel Smith, Margot Quinlan, and CP Hoffman. And then we will hear from another panel after that. So Delegate Belcastro, please.
Thank you, Mr. Chair, members of the committee. For the record, I'm Lisa Belcastro, and I appreciate the opportunity to present House Bill 369, Marriage Records Name Change. Currently in Maryland, we have clear standard procedures in place for individuals seeking to change their name on a driver's license, birth certificate, and other identity documents. And by having these standard procedures in place, agencies like the MVA, Department of Vital Records have clear guidance on how to handle name changes for the documents under their jurisdiction. Unfortunately, these same standard procedures do not exist for individuals seeking to change their name on a marriage certificate. This lack of guidance has led to inconsistencies in how the individual county clerks address name changes on marriage certificates. Some may be willing to make the changes with a specific court order. Some may not allow it at all, or in a number of cases, an individual may be told, and this is the kicker, get divorced and remarried in order to change their name on a marriage certificate. HB 369 seeks to provide clarity and standard procedure in how name changes on marriage certificates are handled by our county clerks. Under this bill, after being presented a court order for a name change, the county clerks would be mandated to issue a new marriage certificate accurately reflecting an individual's new name. Additionally, if the original marriage record issued designates the gender of the parties, the new record must be issued using the now standard gender neutral language. This bill will positively impact any Marylander that goes through the legal name change process and seeks to update their identity documents. However, I'd be remiss if I didn't mention my reasoning for bringing this bill forward. Having accurate identification is an issue of health and safety to many gender nonconforming, trans, and non-binary people who may be subject to discrimination when forced to carry inaccurate or mismatched documents. Due to many unnecessary barriers, navigating the world as a transgender person can be difficult. By removing these barriers, we create opportunities for individuals to live better, more authentic lives. Not having access to accurate forms of ID, such as a marriage certificate, can also be a barrier to an individual being able to access health benefits or proving the existence of a spousal relationship. For example, when an individual starts a new job and wants to obtain healthcare coverage for their family or designate beneficiaries, in many cases, a marriage certificate must be shown. If the name on the marriage certificate does not accurately reflect an individual's name or is mismatched with other identity documents, then this leads to a situation where one must out themselves simply to obtain the benefits that they're entitled to. I want to mention that this bill was introduced last session, but assigned to the Health and Government Operations Committee, and it was in a little bit different form. But in the interim, we worked really closely with the group of county clerks from across the state to get the bill to a place where it can be implemented with success. And while they have taken no official stance on the bill, I'm really thankful for their willingness to come to the table and work with us on this matter. I'd also like to mention that one amendment is included in the committee testimony section of your floor system. It simply strikes the mention of paper records from the bill, and this was based on feedback from the county clerks that it would be too difficult for them to go back and change paper records. So this amendment just ensures that bill's success without it being too burdensome on those tasked with implementing it. So in closing, we have a strong record here in Maryland in reducing unnecessary barriers to the name change process for trans Marylanders. HB 369 seeks to build on those prior successes. Thank you for the opportunity to present House Bill 369. I respectfully ask for your favorable report.
Thank you very much. We'll now hear from Rachel Smith, please, for 2 minutes.
Well, I'm not sure if you can hear me. Can you hear me?
Hear you. Go ahead for 2 minutes.
Perfect. All right. Thank you so much, Delegate Bill Castro, for sponsoring HB 369. Thank you, committee members who are here today to hear our stories. Honorable delegates, my name is Rachel Renee Smith. I live in District 44B. My pronouns are they, them, and she, her. I am privileged to be here with you today, enjoying enormous privilege to represent myself, my loving wife of 10 years, our 3 beautiful children, and LGBTQ families like ours. A bit about me. I came out to my wife as a transgender woman in 2016. In 2019, I obtained a court order that changed my legal name and gender. The circuit court granted me my request that the record of these changes be sealed from public knowledge, or so I thought. Because I was then required to provide the court order to Vital Records to change my birth certificate and our children's birth certificates, to our elementary school and daycare facility, to my wife's employer-based health insurance, as well as to other individuals to change the names on all of our property, etc. Over the past 6 years, my wife and I changed jobs 5 times. Each time we had to submit the sealed court order to explain why our 2011 marriage certificate still displays my former legal name and lists my former gender as the man. With each delay, I felt afraid for the safety of my family. So I called the Baltimore City Department for Marriage Licenses. The clerk there said that there is no legal way to amend or issue a new marriage certificate. It is a historical document certified by the clerk of court under illegal oath to verify that the information contained in it was correct at the time of the marriage. I asked if my wife and I could just get married again to renew our vows. And she said no, that only the first marriage certificate is issued and I cannot get married twice. I can only get married once. To get a new certificate, we would need to first get divorced. I explained that a birth certificate is also a certified historical document and that the circuit court ordered mine to be changed. The clerk recommended that I call the Attorney General's office and ask them to change our Maryland state law. Maryland law presently requires transgender families to out themselves every time that we have to show our marriage certificate. This is dangerous and sends the message to hardworking families like ours that Maryland is not open for business. Please support HB 369.
Thank you very much. I understand that one of the people I've listed is in another committee, that Margot Quinlan is in the Senate. So we're going to hear from, well, we'll bring in Lee Blinder, but we'll go next to, oh, well, I see Lee Blinder. So let's do that. Lee Blinder, if you wouldn't mind for 2 minutes, please.
Sure. Thank you so much, Chair Clippinger, members of the committee, and Delegate Belcastro for your leadership on this bill. I'm here today as the Executive Director of Trans Maryland. We are a multiracial, multigender community power building organization for Maryland's transgender community. Trans Maryland runs the state's largest volume name and gender marker change program, which offers peer-to-peer guidance and financial assistance to Marylanders who are seeking a name and gender marker change. Our name change program has assisted over 300 Marylanders in the last 2 years alone. We hear often from folks who are in the process of updating their legal documents and still cannot update their marriage certificates. This barrier particularly impacts low-income married trans people who cannot hire a private attorney to help protect or update their identity documents. When requesting to update marriage documents, transgender people are being told that they should get divorced and then remarried. This is obviously unacceptable on ethical, moral, religious, and financial reasons. Our policy director was hoping to be here today. However, she's stuck in another bill hearing. So Margot Quinlan was told when she was attempting to update her marriage record so that it matched all of her other state, federal, and financial documents, she was told that she had to get divorced and remarried. She has been unable to update her name on this document alone, which creates an increased risk of discrimination for her family, including for her spouse and her 2 small children. We see this as an unacceptable answer, morally, ethically, and financially. Even a non-contested divorce is expensive, and the simple process of updating someone's name on identity documents should not undertake stressful and expensive legal actions that nobody is interested in undertaking. Passing this bill is a simple step to increase equity and protection for transgender Marylanders, and it benefits a group of us who already face significant hurdles in being seen as our true selves. We really believe that transgender Marylanders must be allowed to access the same rights and benefits as everyone else, and this bill takes significant steps towards that progress. As such, we really urge a favorable report on HB 369.
Thank you very much. We'll go now to CP Hoffman, please, for 2 minutes.
Hello, thank you, Chair, Vice Chair, members of the committee. I'm CP Hoffman, the Policy Director at Free State Justice, which is Maryland's statewide LGBTQ advocacy organization. A lot of what I was planning to say has already been said, so I'm just going to focus on a couple of things. First, I want to emphasize how important marriage certificates are as identity documents. You might think, well, when have I had to show my marriage certificate to anyone? And if you are in a stable job and you've been there for decades, you might not have to. But if you do change your job, like Rachel was saying, or you're applying for public benefits or something like that, you are routinely asked to present your marriage certificate in order to demonstrate that your spouse is a dependent or you're the dependent of your spouse. And so, I have certainly had to present my marriage certificate to do this. And all of those times for transgender folks are situations where we're presenting a record of who we used to be to someone who has an opportunity to discriminate against us. So especially in the employment context, if a trans person were presenting their marriage certificate and that's the only thing that outs them as trans to HR, then they might be treated differently. If they're presenting a marriage certificate that shows that their spouse is trans, that might cause their employer to treat them differently. So there's a lot of reasons that we really think that these documents should be updated. And we can't think of any reason why a marriage certificate should be different than, say, a birth certificate, which we do allow to be updated. As Delegate Belcastro said earlier, we've worked closely with the county clerks over the past year to resolve a lot of the concerns they had. They actually had some great comments along the way. They encouraged us to make the process a lot easier than what we had proposed last year, because they're like, oh, well, really what we need here is just sort of a statement that says we can do this, because there's no existing process in Maryland. And so people who go to the county clerks don't know how to deal with it. And so people are frequently told, oh, there's no process for this. You maybe can get a court order to do it, or you have to get divorced and remarried. Now,
VP,
I'm out of time.
need you to wrap up.
Okay. One last thing I want to say is that if the county clerks don't even tell them that there's an opportunity for a court order, then people don't even know that they can go to an attorney to do this. So thank you very much. I suggest a favorable report on HB 369. Thank you.
Thank you. There's only one other person in the room who's listed as a favorable, and that is Evan Brattel. If we could bring in Evan Brattel, it's listed as a favorable. So we'll hear from them, and then that'll conclude the favorable testimony, and we can take questions. So let's do that. There is another person, for what it's worth, who's listed as favorable, and that's Brian Fisher, but he's from the Baltimore County Historical Trust, and I suspect he was going to be on a different bill. All right, Evan Brattel, there you are. Go ahead. You have 2 minutes, please.
Thank you. Good afternoon. My name is Evan Brattel. I am a proud Marylander and a transgender man married to a transgender woman. Rachel and CP have already covered a lot of the reasons, all the reasons I think why this bill is important. And I just want to speak a little to my personal experience as a resident of Prince George's County. My wife and I were married in Prince George's County in 2014 prior to either of us coming out or undergoing a legal name change. So I legally changed my name first, and when I did, I spent hours on the phone and at least one full workday at the Prince George's County Courthouse, chasing down answers, being given different responses, different information by everyone, and often being told that it was impossible. When I finally got an answer that I would need a special court order, I filed a legal petition and paid the $165 filing fee. And then even with that special court order, when I went to the marriage licensing office, I was met with resistance. I was told, no, it's not possible, and had to really stand my ground to get my certificate updated. When my wife later changed her name, we immediately knew that she needed to file a petition. So she did that, paid the $165 fee. And then again, even with the court order and even with myself having undergone the same process a couple years prior, she was met with resistance. She was told it was impossible and had to stay for an hour with at least one of the clerks telling her, no, you need to leave. We can't do this, until they finally did it. We were very privileged to have the time and the money and the opportunity to fight this and to get our marriage certificate updated so that our documents would be consistent, because for both of us, our birth certificates, as well as all of our current personal identity documents, have our current legal names on them. But the hoops that we had to jump through are not reasonable to expect of anyone, and that makes it essentially impossible for the vast majority of married trans Marylanders. And that's just not acceptable for the reasons that that the other folks who've testified today have already covered. Thank you.
Thank you very much. All right, now we'll take questions. Are there questions for the full panel? Seeing none, that'll conclude the testimony for the favorables on the legislation. We thank you very much. We'll go now to the one unfavorable, Vince McAvoy. Mr. McAvoy, you have 2 minutes.
Thank you so much, committee. Appreciate it. I'm trying to testify yesterday in the Senate. Something happened where I testified on the first bill, but not on the second. It worked out, I guess. So that aside, on Tuesday, Judiciary discussed HB 453, the concept of using a purse, and typically a man's feelings, to arrange placing men in a woman's prison. There are 29 people were to change the entire system against reality. And feminists and lesbians made strong assertions on the opposition panel for HB 453. Here, it's feelings, a paranoid dread, where, yes, complaining about administrative process is going on. This bill wants to change a process that has a problem with bride and groom, and for what? An exceptionally minuscule portion of people in our state. And the basis of the change is their personal issues with biological sex and the difficulty of the fact of man and woman, period. And what this bill asks of you and the court and the clerk and everybody is to validate a lie, mental illness, and potentially criminality, as this bill will be abused through the loophole that this bill would create. It's unbalanced, dishonest, and a slippery slope of identity theft. That's what was mentioned in the JPR regarding the potential for this bill to be used when getting spousal benefits. So the very fact that that was brought up points to the fact that this bill can be abused. Also, there's issue with, it looks like this bill is trying to call dead name a death certificate. This is, again, just buying into a lie. This is a very complex way when they themselves have said it'd just be simple to go ahead. They don't honor marriage as a sacrament. So if they want to go and go through procedural issue of getting divorced and redoing it, that will work with the existing system without changing all this thing. And I'm very troubled by the fact that other peoples who don't identify at all with this are going to get their marriage certificates or leaning on the system, taking away these facts of man and wife, bride and groom.
Mr. McAvoy.
Okay, I have others. I'll take any questions if you all are ready. Thank you so much.
Are there questions for the witness? Seeing none. Delegate Cox.
Thank you, Mr. Chair. I just wanted to ask Vince, I didn't quite hear the last part, and I think you said you had one more point. Could you clarify that for me?
Thank you. I appreciate that, Delegate. This bill is going toward a gender neutral issue. When we're looking at what we have in this state, and I did the math on last term, I'm sorry, I can't remember it off the top of my head, but my calculation was something like 99.82% of all cases in Maryland are bride and groom, husband and wife, man and woman. This, by definition, should be an other. This bill shouldn't exist. We're talking about an infinitesimally small portion. This bill can be abused, loopholes, increasing criminality, and it's going against our tradition. It's going against our belief system of 99 point, I forget the number, like 82%, something like that. Thank you for asking, Delegate.
Delegate Cardin.
Thank you, Mr. Chair. Just very quickly, Mr. McAvoy, I don't understand. You sat there and you're arguing that there's this is a small number, but you haven't yet said one reason why this is in putting any of the other people, those 99% of other people that you are referring to, in harm's way.
John, read the bill, and I'll cite it to you, okay? On page 2, section B1, what is it? I. No, I'm sorry. B1I. Designate the parties using gender neutral language. Okay, this is not just, and you know this, come on, you know this. This is not just a matter of fact. This is a matter of ideology, okay? And that's just simply not the ideology that the vast majority of Marylanders hold. So,
but you still haven't, I don't understand why there's any harm that's being provided to people who may be like you and don't agree. By the way, I believe it's also present law that all new marriage documents have to be gender or can be. I don't know if they have to be, but they can
so
be.
That's what I'm talking about. That's exactly what I'm talking about.
What I'm asking you is very simple. How does this, if as you are indicating, it's a smaller percentage of people that this would impact, how is this harming the other people out there? to be able to do this and provide this service for this group of people?
Because of, okay, to answer, because of issues that were brought up by John Morrissey last year in discussing, I'm sorry. I don't want to misquote his name. Because of issues that were brought up regarding this with the courts and the clerks, I don't want to put him out there. Regarding a move with the new system where it would increasingly move to a genderless system. That's just not the case. That's just not the fact of Maryland. So you say, well, how does this particular, no, well, we know how things work in Annapolis. So do you, obviously, that these things are done smallly and incrementally. Nothing I've ever seen happen in Annapolis happen overnight. Everything is these little tiny steps. And before you know it, you don't see bride and groom on there. That's what we have in this state. Bride and groom, 99.8 something percent. That's why the bill shouldn't be considered. In addition to the fact that this is, when you look at it, it says that we will take where is it? From any state, regardless of location. That's what it says. This is way too broad and opens way too many windows. And again, these are people complaining against reality, and we're buying into them, into their belief. That's not based on reality, to change our system. If I went ahead and said, you know, I'm not going to do that. I'll just leave it there.
Are there further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 369. We'll go now to House Bill 338. Delegate Lopez, this is a new bill, so 3 minutes for the sponsor, 2 minutes for everybody else. Several people to testify. Let's just look at this. Okay. Do a couple panels. Delegate Lopez first, then Madeline Ziegler, Lee Goodmark, and Sabrina Rubis will testify first. And then we'll go to another panel after that. It looks like there'll be 5 on that panel. So we'll go ahead. Delegate Lopez, please, for 3 minutes.
Thank you, Mr. Chair and judiciary colleagues. For the record, I'm Delegate Leslie Lopez here to urge your favorable support for HB 338. This bill protects victims of domestic violence by clarifying what constitutes neglect, removing a barrier that many in abusive relationships face when they try to leave. In layman's terms, reaching out to authorities for help for domestic violence should not endanger your ability to parent or trigger separation from your children. The goal of this bill is to ensure that good parents can retain custody of their children when they are seeking help for domestic violence. Please know that we are in continued talks with stakeholders about amendments to ensure this bill has no unintended consequences and keeps all children safe. Intimate partner violence victims face numerous obstacles when they attempt to leave the abusive situations, including fear of homelessness, financial instability, and lack of social support. Maryland law currently creates an additional hurdle for domestic violence victims who attempt to leave by allowing them to be charged with neglect, making them fear losing custody of their children as well. Currently, the definition of neglect in Maryland's code is broad enough to encompass many types of neglect. However, the broad definition allows domestic violence victims to be prosecuted if their child witnesses abuse in the home or for failing to leave their abuser. We should not punish victims for the abuse that they are enduring. Fear of this kind of prosecution incentivizes victims to stay quiet about the abuse that they are experiencing out of fear that if they notify anyone, they will be charged with neglect and their child will be sent to foster care, which is often an extremely traumatic experience for both the parent and the child. So in conclusion, this bill will help ensure that Maryland does not unduly prosecute victims of domestic violence who have the strength to come forward for the actions that their abuser commits. Thank you, and I urge your favorable report.
Are there, well, not yet. Let's go ahead to Madeline Ziegler, please, for 2 minutes.
Good afternoon. My name is Madeline Ziegler, and I'm a student attorney with the University of Maryland Justice for Victims of Crime Clinic. Our clinic represents crime victims in a broad range of legal matters. As has been mentioned here today, our current laws related to child abuse and neglect punish victims of domestic violence for any delay in reporting their abuse or leaving the relationship. Our clinic serves immigrant clients who specifically delay contacting law enforcement and pursuing legal remedies for many legitimate reasons, including barriers related to language, education, culture, and fear of state authorities. Our clinic served an immigrant crime victim who was devastated to find that her partner and co-parent sexually abused their daughter. She was terrified that police would not believe her and would not help her because of their immigration status. Our client worked day and night to scrape together enough money to leave the abuser and find a safe place for her children to live. Like our client, many recent immigrants don't know that help is available since their undocumented status precludes them from other social services. Steep financial barriers also make it difficult for immigrants who are victims to leave their abusers. We represented a client who survived a decade of brutal domestic violence in Baltimore. Because she had just immigrated to the United States, she was fully dependent on her abuser for money, food, shelter, and their child's welfare. Luckily, our client eventually found support and strength to leave. However, under our current child abuse and neglect laws, the state could have removed our client's children from our custody at any time simply because they witnessed the domestic violence. The current law essentially uses the child welfare system to punish victims of domestic violence, which actually harms children. Research demonstrates that even temporary separation from a parent can cause serious and permanent emotional harm to children. Despite this, children are placed in foster care far too often, even when a loving, supportive, non-offending parent who was also a victim remains in their home. Children should only be removed when the safety of the child is threatened and no safe caretaker remains in the home. House Bill 338 will support victims of domestic violence and help Maryland's children by giving families a greater chance to preserve safe relationships within the home. Thank you.
Thank you very much. We'll go now to Leah Goodmark.
Good afternoon, Chairman Clippinger and members of the committee. My name is Lee Goodmark. I am the Marjorie Cook Professor of Law at the University of Maryland Carey School of Law and the Director of the Gender Violence Clinic. The problem of holding non-abusive parents responsible for the actions of their abusive partners using what are called failure to protect laws is one that people in child welfare, the judiciary, and the domestic violence community have actually been working on for quite some time. In 1998, the National Council of Juvenile and Family Court Judges published what is called the Green Book. It's also known as Effective Interventions in Domestic Violence and Child Maltreatment Cases, Guidelines for Policy and Practice. The Green Book lays out foundational principles for addressing cases where domestic violence and child abuse or neglect are co-occurring. And the overarching message of the Green Book, which was put together by really the best experts in the country on these issues, is that children and their non-abusive parents should be kept safe and together, and that non-abusive parents should not be penalized for being abused. A federal court further underscored this message in 2002 in a case called Nicholson versus Williams, where it found that Child Protective Services' practice of removing children from the custody of their non-abusive parents for failure to protect infringed the constitutional rights of those non-abusive parents. And yet, as you just heard, child welfare agencies in Maryland continue to hold non-abusive parents responsible for the actions of their abusers, removing their children, seeking findings of neglect, and in some cases, seeking terminations of parental rights. You will hear from Gender Violence Clinic student Sabrina Rubis about how difficult it can be for non-abusive parents to leave their partners and all of the barriers that exist to help seeking. And you've already heard a little bit of that already. Knowing that Child Protective Services might take your child if you identify yourself as a victim of domestic violence is yet another reason why parents who are being harmed don't seek assistance. And remember that they're seeking assistance in many cases from people who are mandated reporters. So this isn't a theoretical problem of being exposed, it's a very real problem. The possibility of intervention by Child Protective Services in these cases makes conditions for children less safe, not more safe. This bill will make it easier for parents who are being abused to come forward to seek services and assistance, knowing that disclosing that they are being abused will not be used to take their children from
Ms.
them.
Goodmark, if you wouldn't mind wrapping up.
I am finished. Thank you.
All right, thank you very much. Sabrina Rubis, please.
Yes, thank you. Good afternoon, everyone. My name is Sabrina Rubis, and I'm a student attorney with the Gender Violence Clinic at the University of Maryland Francis King Carey School of Law. I'm speaking today on behalf of the clinic and in support of HB 338. There are many reasons why people are unable to leave abusive relationships, including but not limited to physical, psychological, emotional, or financial abuse. Many of our clinic's clients have experienced this victimization by their partners, and each had their own reasons for not leaving, and leaving doesn't necessarily stop the violence. For example, one of our clients dealt with a significant history of domestic abuse. Her husband physically assaulted her on several occasions, threatened her, and almost strangled her to death. Before the two separated, when our client was still living with her husband, he used money to control her and still does, although they are separated. Every 2 weeks when she received her paycheck, she had to give the entire paycheck to her husband. She was not able to save money during the marriage, which made it very difficult for her to leave as she was only working part-time and she knew that her income was not sufficient to cover the bills on her own. He also harassed her boss, telling him how horrible she was until her boss grew tired of it, which ultimately led to her getting fired. Our client struggled with leaving her husband because, like many mothers, she wanted their daughter to have a relationship with her father. He never hit the child, and she knew that her daughter loved him, so she stayed as long as she could. When the abuse did not stop, our client had enough and tried to leave. She received a final protective order and filed for divorce. And although our client believed she would be safer after signing a separation agreement, the abuse did not stop then, and he assaulted her immediately after they signed the agreement. Our client's partner used finances to control her and make her live in fear, a tactic frequently used by abusive partners. We have hundreds of stories like this one. This client, like many others, loves her children, and nothing is more important to her than her children. But leaving an abusive relationship is far from simple and can be a long process rather than a one-time event. Ultimately, this bill will help support women like our clients who have many reasons why they struggle to leave abusive relationships. This bill could mean the difference between penalizing a victim and empowering them to leave these very situations. Thank you.
Thank you very much. We'll take questions for the panel now. Does anyone have any questions for this first panel? Everyone is trying not to wake Delegate Lopez's son. Are there questions for the panel? Delegate McComas, are you trying to raise your hand and can't figure out how to, there we go. Please unmute yourself. Delegate McComas.
It has been an interesting day. Machinery and I don't get along. I guess this is for any of the panelists. I'm sure you're all very familiar with ACEs, Child Adverse Experiences. And I guess what I'm concerned about is that if none of the abuse is going to be that the abused person is not going to be held accountable. Obviously, there's a codependency between the abuser and the abused, and it's very, very complicated. But my concern is that the kids are basically in the middle of a bad situation, and I think seeing their parent, whichever parent it is, being constantly abused, either emotionally, verbally, physically, is not good for the kid. And so I understand what you're trying to do, but I think you're giving the person who is codependent with that abuser a pass, so they don't take action. And that's I'm a little concerned about. And I wish you could address that issue, because with ACEs, it's not good for a child to one, see violence, and to see, to just see this constant, not a loving relationship, just a bad relationship. It's not good for the development of the child. So I'd like you to address that, why this is good for the child.
So Delegate McComas, I couldn't agree with you more that the research shows that ACEs are absolutely destructive to children, and the greater the amount of violence that they witness, the worse it's going to be. But intervention by the child protective system isn't the only way to make sure that that doesn't happen. And in fact, having the threat of a neglect finding over your head makes it less likely that someone's going to come forward to seek services to help them get out of an abusive relationship, not more. So if we think about interventions that might actually help people get to safety and keep their children from witnessing these kinds of things, we can think about things like improving the service provision sector, putting more money into social workers, putting money into kind of family reunification, or not, that's not what I meant to say, putting money into services that help people have the economic wherewithal to be able to leave an abusive relationship, give them the supports they need to live independently, give them housing, give them all kinds of other things. But a neglect finding is not the kind of the vehicle to make that happen. And the fact that a neglect finding can happen is keeping people from coming forward and seeking those services. So, not every relationship is a codependent relationship. And we have lots of clients who want more than anything to leave. But as Ms. Rubis explained, First of all, leaving doesn't necessarily make you safer. Our client was absolutely assaulted right after she sought a separation agreement. And even if people want to leave, they don't always have the ability to do so. So it's not necessarily about the intent to continue to expose the child to this kind of bad behavior or this kind of damage. It's about making sure that people have what they need to be able to live safely together with their children. The neglect system isn't doing that currently, and we think there are better ways to do that. And decreasing the likelihood that someone will be brought into that system, I think, is going to bring more people forward to seek help.
Just a real quick question, follow up, Mr. Chair, if I can indulge. How many situations have you done any, let's say, analysis or statistics as to how many situations have, when the woman has not responded to the abuse, that she's been, found to be neglectful and lost custody? Do you have any data on that so we can kind of see how big the problem is?
Yeah, I don't have that data statewide. That data is very hard for us to get our hands on. Madeline?
Yeah, I could just jump in here for a second. There was in the National Child Maltreatment 2019 report that's created by the, I think it's the administration of the Children's Bureau. They found that in Maryland in 2019, of children that were found to be victims based on neglect, about 39% were found to be victims of neglect based on just domestic violence within the home. So though those statistics, I don't have the details right now exactly of more than that, what I do know is that this is not an uncommon occurrence that someone could be classified a victim of neglect simply because there's domestic violence within the home.
Could you just supply the link of that report? That would be great if you can do that. Thank you. Thank you, Mr. Chair, for indulging me.
Are there further questions for this panel? Seeing none, thank you all very much. We'll go to the second panel. We'll also take the favorable with amendment here. The following four are just favorable. Danielle Pollock, Melanie Shapiro, Nina Villamar, Richard Perry. We'll also hear from Shanta Trivetti, who is favorable with an amendment. So if we could hear from Danielle Pollock, who I believe is already unmuted. We'll hear from Danielle Pollock. That would be great.
Hi, thanks for having me today. Chairman Clippinger and committee members. My name is Danielle Pollock. I am the policy manager. Can you hear me okay? Yes. At the National Family Violence Law Center at GW. We are the first national research center specializing in the intersection of adult and child abuse in the family and its implications for family courts. We support HB 338 and recommend a favorable vote. It's an important bill which is sensitive to the unique challenges that domestic abuse victims face when they share children with their abuser. The provisions in this bill will create a more nuanced and sympathetic approach to these very difficult cases. Neglect definitions have long been misapplied to domestic violence victims, deeming them as the source of harm when they themselves are victims. And this results in compounding harms for themselves and their children, and even more hurdles for them to reach real sustainable safety, as some people have testified previously. So I'd like to talk just for a moment in practical terms about what is happening with the victim who is also a parent who is not leaving the abuser or who is leaving and returning. On average, the parent victim makes several attempts to leave the abuser, 5 to 7 times on average, before being able to really fully extract themselves and their children for the long term. And of course, some never make it out alive. Within these many attempts, a lot is going on, which perhaps for someone on the outside, like a caseworker, they may not fully grasp what strategies the protective parent or the safe parent or the victim parent is taking. It may seem illogical, but she knows, it's usually a she, but not always, she knows better than anyone else the sort of degrees of risk and the expected and anticipated response from the abuser. And abusers are manipulative and they're interested in controlling their victims. So simultaneously, they're employing a variety of types of control and oppression. Direct violence is just one of those things. They're also controlling resources And importantly for today's discussion, they're employing psychological abuse to break down the victim's sense of self, and that they matter and that they have the capacity to exit.
Ms. Paul,
Yes.
we'll need you to wrap up, please.
Okay. So if they're penalized for trying to exit with a neglect determination over their head, it decreases their likelihood for being able to escape. So it's really not the right approach to mark them this way.
All right. We thank you very much. We'll hear from Melanie Shapiro next for 2 minutes.
Good afternoon. Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence. I'd like to thank my prior panelists who have covered a lot of the information I intended to cover, so I will not repeat it. But what I will share with you is from programs that are part of the network in Maryland, part of the Maryland Network Against Domestic Violence. They've reported to me that victims have told them that they've not sought services out of fear of DSS involvement. The health practitioners that work there and might be providing counseling services are in fact mandated reporters. And so if something is disclosed to them, then they must then make that call to the Department of Social Services. In addition, we have heard reports that individuals have not participated in the lethality assessment screening, the LAP, which is done when most often when police respond to a domestic violence call, and it screens for high lethality. And they haven't participated out of fear that if they screen high, that then DSS will become involved. And to Delegate McComas's question regarding trauma, it is absolutely a trauma to witness domestic violence. It's in fact one of the original 10 ACEs. However, removing a child or DSS involvement itself is also a trauma. And there's research that demonstrates that the psychological trauma caused to a child by being removed from their home, even if they've been a victim of abuse, is outweighed. That trauma is greater than if they had remained in their home to start. And so we don't think that you respond to one trauma by causing another one. We think that HB 338 says to survivors that they are supported and encouraged to seek help and can do so without the fear that DSS will get involved and possibly remove their children. So for those reasons, we urge a favorable report, and I'd like to thank Delegate Lopez for bringing this bill.
Thank you very much. Nina Villamar.
Thank you. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Nina Villamar, and I am the Chief Attorney of the Parental Defense Division of the Office of the Public Defender. Let me first thank Delegate Lopez for sponsoring and introducing this bill and advancing the interests of children and their abused parent. We at the Parental Defense Division represent parents in court when the Department of Social Services initiates a child in need of assistance case and accuses the parents of abusing and neglecting their children. In most cases, DSS separates the children from their parents and places them in foster care. I respectfully ask for a favorable report on HB 338. In the majority of cases, there is more than one reason that the DSS is accusing the parents of abuse or neglect. In cases where there's domestic violence in the family, DSS will accuse the abused parent with neglect for failure to protect the child from witnessing or being exposed to the domestic violence. These are cases where the child is not actually the direct victim of the violence. HB 338 would take the failure to protect charge against the abused parent off the table. For all the reasons that you heard previously in previous testimony, we know that the evidence shows that the victim of domestic violence doesn't leave the abusive partner or take other actions for a lot of different reasons, but not because she is choosing her man over her child. Accusing DV victims of neglecting their children because they failed to protect them from witnessing or being exposed to domestic violence, and then using that as a reason for separating the children from the abused parent is both harmful and cruel to the abused person and to the children. And let me add, it is not economically in Maryland's interest to use its resources to place children in foster care when they could be remained with their non-abusive parent. Furthermore, it subjects the parent and the child to further trauma. Aside from the trauma of being abused, they have to experience the trauma of being separated from each other. While the trauma of being abused is inflicted by the abuser, the trauma of being separated is inflicted by the state. HB 338 can help prevent this trauma of separation by not letting the abused parent be accused of neglect because of the actions of the abuser. For these reasons, I respectfully ask that you issue a favorable report on HB 338. Thank you.
Thank you. Richard Perry, please.
Thank you. Good afternoon, Honorable Chair Clippinger and committee members. I'm Richard Perry, Senior Senate Attorney with Maryland Legal Aid. Thank you for your invitation to Maryland Legal Aid to present testimony on HB 338. We testify in opposition to HB 338. We represent indigent people in civil matters throughout Maryland. As part of this,
sorry, Mr. Perry, did you just say that you testify in opposition?
Yes, sir. Yes, sir.
Right. I'm going to ask you to hang on. We're in a panel of people who support the legislation.
Okay.
Keep you separate from that, and we'll come to you here in a moment. The next person was Shanta Trivedi, and she was testifying favorable with amendments. So
Thank you.
Yeah, we'll hear from you for 2 minutes.
Okay. Good afternoon, Mr. Chairman, Mr. Vice Chair, and committee members. My name is Shanta Trivedi, and I'm an assistant professor of law at the University of Baltimore. I teach courses on family law and the child welfare system, and I've written extensively on family separation and specifically on the harm to children when removed from their parents. I've represented hundreds of parents in both domestic violence and child welfare proceedings. In addition, I serve as the faculty director of the Sarah Neil Meyerhoff Center for Families, Children, and the Courts, or the CFCC. I'm also a parent to 2 young children. I urge you to issue a favorable report on HB 338 and to consider potential amendments. Accusing people who currently experience violence of neglecting their children is a cruel and misguided practice. It tells people who are struggling to survive themselves that they are somehow responsible for the behavior of the offending party. As I'm sure you know and others have testified, the reasons that people do not leave their abusive partners are complex, and there's no one-size-fits-all approach to intimate partner violence. Unfortunately, DSS usually suggests exactly one approach: leaving. Immigrant clients may fear reporting violence due to their immigration status. And unfortunately, many of our citizens, particularly those who are Black, have a deep mistrust of the police and the legal system that may prevent them from reporting. State intervention can also escalate the violence and make the problem worse, which serves neither the survivor nor the child. Accusing survivors of neglect due to failure to protect from exposure to domestic violence also sends a message to children that their survivor parent has done something wrong when she has not. Worst of all, it puts children at risk of being removed from a blameless, loving parent who is perfectly capable of caring for them. Removing children from their parents has absolutely devastating and permanent effects that will affect them for the rest of their lives. Many will end up in foster care, and sadly, some foster parents cause more harm than good, and many children experience abuse in foster care. Foster children have worse outcomes than their peers on metrics ranging from behavioral and mental health, substance use, teenage pregnancy, juvenile justice system involvement. Unnecessary removals such as these undermine the goal of the child welfare system by inflicting harm rather than protecting children. As written, however, the bill does not provide a mechanism for the state to provide assistance in a non-punitive way. CFCC therefore proposes an amendment that would allow DSS to provide support for survivors who want to leave violent situations if it is safe and practicable to do so.
Okay.
I urge you to support HB 338 with such an amendment.
Thank you very much. That concludes the favorable or favorable with amendment testimony. We'll take questions now. Delegate Cardin.
Thank you very much. Thank you all for your very compelling testimony on this important legislation. I'm not sure, I only need one person to respond, but I don't know if it's Ms. Shapiro or Ms. Villamar, perhaps, or Ms. Trivedi, I don't know. But from all of your testimony and from the testimony that preceded you, it seems to me as if the abused person in the relationship could be charged with neglect and could have a child taken away from them for failure to protect the child from witnessing the abuse. Is that my, just yes or no, is that my understanding of what the problem is? Is there any training or anything going on at DSS to try and explain to them the complexity that Ms. Trivedi just spoke about? I mean, it seems to me like, I know that it's frustrating that you have to come to us when it seems like this is an issue that DSS should be dealing with from a regulatory and educational perspective.
Thank you so much for that question, Delegate Cardin. I'll attempt to answer your question. I'm unaware of any training that DSS does. I don't know what's part of their trainings. But the issue is, and I think Ms. Villamar discussed this in her testimony, is that DSS might become involved in a case because of something that's happening to the child. And then there's also DSS. So the allegations are against the abusive parent for one thing, and then they also charge the other parent with basically failure to protect. And so just by being a victim and not leaving or getting a protective order. And so the child then gets removed from both parents, as opposed to providing the services, or not even services, as opposed to allowing the child and have no DSS case against the victim parent and the child. And so that at least is what I have historically seen. And Ms. Villamar has had the most experience in terms of the cases, in terms, of what she's seeing. But that's, I think, part of the issue. And the other piece is that there are numerous programs throughout the state of Maryland that, in fact, make up the network against domestic violence that can provide services. So while there is a need for DSF to have the training, those services do exist if a person is ready to leave. But you have heard all of the reasons why somebody may choose or be unable to leave a situation, a violent situation.
Elliot Cardin, I can further explain if you would like. May I?
Go ahead.
So in the majority of cases, the fact that there is domestic violence in the home is rarely the only allegation. However, because the courts have to look at the totality of the circumstances, the fact that the abused parent has not left the abusive parent, the violent parent, is one of the factors that the court will take into consideration in coming to a conclusion that the non-abusive parent was also neglectful. What we are hoping this bill will do is to take that off the table, so it's not a factor that the court can consider when looking at the totality of the circumstances and making a conclusion about whether the child has been neglected and whether the child needs to be removed from the home.
Are there further questions for this panel? Seeing none, thank you all very, very much. We'll go now to two people testifying in opposition. We'll hear now from Richard Perry and then from Vince McAvoy. So Mr. Perry, if you're still with us, there you are. Go ahead. Now you can have your 2 minutes in opposition.
Good afternoon, Honorable Chair Klibinger and committee members. I'm Richard Perry, Senior Senate Attorney with Maryland Legal Aid. Thank you for your invitation to Maryland Legal Aid to present testimony on HB 338. We testify in opposition to HB 338. We represent indigent people in civil matters throughout Maryland. As part of this representation, we provide legal services to thousands of Maryland children every year in child in need of assistance cases. We are the ones who actually represent and work with the children in these cases. We are profoundly concerned with problems of domestic violence. We help DV survivors obtain protective orders, and we help survivors in divorce and custody proceedings. We understand the complexities involved in this area. Society must help victims of domestic violence in a way that does not endanger the health and safety of children. Children who are exposed to domestic violence may be placed at substantial risk of harm. Witnessing a parent being abused can do serious mental and emotional damage to children. We have represented children who have themselves started to exhibit aggressive and violent behaviors after exposure to DV. Children may also be physically injured directly in DV episodes. Currently, Maryland's judges in Senate cases have the ability to exercise their discretion and take action to protect children from the harms stemming from domestic violence. HB 338 would remove judges' discretion and would take the category of the least powerful members of society, children, and make them categorically and by definition excluded from protection in DV situations. The department has the ability to offer immediate shelter and other services. If there's an overreach by the department in a DV case, there are mechanisms in place now to combat that. The current law is that children may only be removed and may only be found SINA where the judge finds that there is a substantial risk of harm to the child. We are not encountering cases where a child is removed or found SINA in a DV situation where there is not a real risk of harm to the child. We certainly do not see 39% or any similar percent of cases where neglect is based on witnessing domestic violence. HB 338 would remove the ability to protect children in DV situations, even where there was a substantial risk of harm to the child. It would work a major change in the law, and this will endanger and ultimately injure children. We would be happy to work with others to craft a bill that would help adult victims of domestic
Mr.
violence
Perry.
without harming the children or putting them at risk.
All right. Thank
So
you
we
very
request an
much.
unfavorable report. Thank you.
Thank you very much. There are actually 3 people in opposition, and I left off Paul Griffin from the next page. We'll hear from Mr. McAvoy now for 2 minutes, and then Paul Griffin right after that. Vince McAvoy for 2 minutes, please.
Thank you, committee. I urge an unfavorable on this. I'm going to have to regurgitate what Melanie Shapiro said about responding to one trauma by causing another. When we resume Bobby Zirkin's bill about mothers stealing children during the Pendente Lite for the DCM track, but that's next year. Here, I remember a case on Reisterstown Road in Baltimore where we had a murder. Murder was perpetuated by the father, and the mother was there, and they were in a hotel room. Child died, drugs involved. This bill would be giving a crutch to that mother. And I appreciate that we have so many Senate people on here. Of course, I was down there at DJS on the 2nd floor where we had I don't think the person was talking about family unification, but family preservation. Basically what that is a huge file room down there of all manner of mother drug addicts who have had children taken from them. Why were they given to the mother? Well, because the other, the husband or the boyfriend might be in jail or might have had something worse going on. I've also had fathers who have come to me stating that they cannot effectively get a modification in custody because they're not getting any help from the mother, who knows that would decrease the money going to them via child support and so forth. And remember those factors, right? These factors, if they were brought up during the child custody hearing initially, they would have impacted the case. A primary caregiver, if the mom's giving the primary care to a drug addict or someone who's going to harm the child, that's not the primary caregiver, and that should have been, put into the factor. But now after the determination, we can't get there. So that's a real issue with this bill. I just in closing, speaking to children, think about this. We're talking about people who are watching their children. Forget the actual physical harm. They're watching this stuff going on. What kind of a mother are you when you allow this to go on and you're saying, nah, we're just going to go ahead and work through it? Meanwhile, your kid's getting shocked and horror. I urge an unfavorable on this bill, and thank you so much.
Thank you very much. Mr. Griffin, please, for 2 minutes. Mr. Griffin, you're muted. You're going to have to start over.
All right, apologies. Thank you, Mr. Chairman. My name is Paul Griffin. I'm the legal director of Child Justice. Child Justice represents victims of domestic violence in custody cases involving domestic violence or child abuse. I'm also a member of the Committee to Protect Maryland's Children, which has come out in opposition to this bill. The members who are opposed it include the Board of Child Care, CASA, Child Justice, the Citizens Review Board for Children, the Family Tree, Legal Aid, the Maryland chapter of the Academy of Pediatrics, the Maryland chapter of the National Association of Social Workers, and the Maryland State Council on Child Abuse and Neglect. I'm in the unusual position of coming on a bill that seems to be in opposition to victims of domestic violence because I represent them. I've done hundreds of cases involving victims of domestic violence. And I can tell you anecdotally, and this may be other people's experience, I've never had a single case where a victim was trying to extricate herself from a relationship where it was domestic violence, where she was ultimately indicated for either indicated for neglect or criminally charged. It's never happened in any of my cases when someone was trying to get out of that relationship. I was a member of the work group to study child custody court proceedings involving domestic violence. And one of the findings that we had was this: children having exposed to domestic violence are more likely than their peers to exhibit signs of depression and anxiety, fear and withdrawal, low self-esteem, and higher levels of anger and disobedience. It also has a much higher risk of normalizing violence, increasing the risk that children become the next generation of victims and abusers. And finally, exposing children to domestic violence is one of the identified ACEs. And this exposure gives us a risk factor for some of the most common causes of death in the United States, including substance abuse, smoking, and obesity. Domestic violence is a terrible thing to expose a child to. It is a form of child abuse, in our view, even though it's not legally recognized that. We believe carving out an exception is not the way to do things. We would happily work with the sponsors of this bill to come up with some language that we all can agree with. But we believe that if, particularly in the more horrific cases of domestic violence, that DSS has to have the discretion to act in those cases and do what may be appropriate at the time. But let me also say that a finding of neglect does not necessarily equal removal. There's a big process that's involved in doing that. And usually parents that they don't want to remove, usually parents are given opportunities to correct the subject of neglect.
Mr.
So
Griffin.
I was going to say that we believe that finally, the last thing I would point out that if no discretion is given to DCS on this case, they're not allowed to provide services for the family, which they can provide if they have a finding of neglect or have the ability to make a finding of neglect. So we urge an opposition. We urge a negative report on HB 338.
Thank you very much. We'll go to Delegate Lopez, then Delegate McComas for questions. Delegate Lopez.
Thank you, Mr. Chair. My question is for Mr. Griffin. You listed off a number of organizations that are in opposition to this bill, but I don't see any of them listed as actually submitting written testimony or oral testimony. So just for the record, can you explain how exactly you came to feel that these organizations are opposing this and what evidence you have of that?
Sure. The Coalition to Protect Maryland's Children submitted a written opposition, and that was on behalf of those organizations that voted in opposition as the members of the coalition. So that's how their opposition is noted.
For what it's worth, I attend those meetings as well, and I was able to observe all of the representatives from all these organizations discuss the matter thoroughly and come to those conclusions.
As was I.
Thank you both. Mr. Perry, thank you. Mr. Perry, I'm under the understanding for our ethics in which we operate that the organization you represent is not technically a registered lobbyist. And so in order to testify here today, you had to be invited. Can you explain the circumstances of your invitation?
Personally, I was told that we had received an invitation and therefore we are here to testify. What I would have to ask others about who provided the invitation, honestly.
Well, as per our ethics rule, it'd be ideal if you could supply that.
Okay.
Delegate McComas.
Thank you, Mr. Chair. I have a couple of questions and of either Mr. Perry or Mr. Griffin. And the question is, okay, so we keep the neglect in the statute. There are different mechanisms before you rip the child out of the house. And I would like you to detail what those mechanisms are when their social services is called. And I'm talking about reunification, all the different things that they would do before they would, take the child out of the home or from away from the parent and charge them with neglect. So if you could elucidate, that would be great.
I'm happy to. So again, we see these kinds of cases. In practical reality, the department will talk with the family, work with the family, enter into a safety plan, try to provide services. Usually after that has failed and there are additional increased concerns about the safety and welfare of the child, at that point, there might be a petition, a Senate petition, but the Senate petition itself does not necessarily mean removal. There are orders controlling conduct or an order of protective supervision that can be put in place where the child remains with the parent under the custody of the parent, but under the guidance and orders of the court. And then if the situation is sufficiently egregious that there is a removal, then the goal is reunification to put services in place there. Again, the judges, by law, cannot remove a child unless there's a risk of harm and cannot find a child a SINA unless a child in need of assistance, unless there is a risk of harm. So there are many steps and many services that are available. But there is the ability right now, if there is a real risk of harm, for the court to make the intervention that the court feels is necessary.
And if I can add to that, my understanding, and I don't do SIM cases, but my understanding is when it comes to neglect, they don't do them retrospectively, meaning they don't say you were neglectful last year when you lived with your boyfriend who was beating you up in front of your child. They look at where things are at the given moment. So you are still in this relationship, it's going to be a problem. Obviously, if you're in the attempt to extricate yourself from it, and I recognize, having dealt with hundreds of these cases, that usually first time is not successful and it takes several efforts. But if the court is seeing this person has either extricated or in the process of getting out of this relationship, there's not likely to be a further finding of neglect, certainly not sufficient enough for the judge to want to remove the child on a sin action and put it in foster care.
So let me ask this question. If we pass this bill, okay, without amendments or anything, those folks that might be able to be benefited by counseling, reunification, help by social services, and a program and somebody to monitor what's going on without charging them with neglect, that ain't going to happen, right? That's gone.
That's our concern.
I believe that's correct.
That's our concern.
So that is the, what do I want to say, unintended consequences of this legislation, and it's a big concern to you folks, right?
It is, and it's also, it is.
And you guys work with these kind of cases all the time.
I work with custody cases with domestic violence and child abuse, and it's usually a mom, almost not always, but usually trying to get out of her, and the domestic violence is getting out of a case where she was a battered spouse, and we're trying to get them out of the case and get them out of that relationship and get them custody of the child, because we believe they, as a protective parent, are a far better parent than the domestic abuser is. And we are going to, unfortunately, we fear, see instances where CPS finding neglect may be what it took to finally help push or persuade that victim to finally leave a relationship. But the CPS will have no jurisdiction doing that. If they don't have the ability to make a finding of neglect, they're going to do what's called a screen out. It's going to be, we can't do anything here. They're going to screen it out. Nothing will happen. We fear that there are going to be instances where someone will stay in their relationship when perhaps with some counseling and other services they would have gotten out, and then a child may witness his or her mother being murdered in front of their very eyes. That's a concern, a genuine concern we have, because we know what happens.
Okay. Thank you, gentlemen.
Thank you.
Delegate Cardin, then Delegate Shetty.
Thank you, Mr. Chair. Let me just, so are you guys opposed to the prohibition of removing a child? Is that my understanding?
There are
prohibition against removing a child.
So the current law says that a child can be removed in situations where it is necessary to protect the child's welfare.
Right. And this doesn't change that, right? This doesn't change that.
It does.
I believe it does.
I believe it does too.
So does this prohibit the ability to remove a child if it is in the best interest of the child?
Yes, I believe that that is the fear of the.
Certainly.
Okay.
Certainly under certain circumstances it would.
Okay, under certain circumstances. So if in the narrow, let me just make sure I understand it. In the narrow circumstances that the neglect is going to be defined as the person who is the victim doesn't stop the child from seeing the abuse happening. In that instance, you are defining neglect out of the statute for the purposes of removal of the child. That's the instance that we're talking about, right?
The statute as drafted is drafted so broadly that it's not clear. It could be argued that any injury to a child that happened in a domestic violence situation could be immunized from helping the child. If it's not clear, I think you'll definitely get arguments that, well, the child was injured in the domestic violence situation, but that is actually just an offshoot of failing to get a protective order or failing to leave the person.
Right, but that's an issue of fact for the fact finder, wouldn't that be?
No, because this bill would take that away as an issue for the fact finder. I mean, that's the fear, is that this bill takes all of that away from the judge and takes it out of the judge's discretion. So it's not clear that even with serious risk of harm or harm, that they could be protected under this bill.
I mean, maybe I'm just reading the language of the bill, and I just don't. I understand that you guys don't want to narrow this at all, but there is an issue here where we have children being improperly taken away from a parent that they should be with. And you're saying that we have to be able to give the judge the ability to do that, even when it's not the appropriate thing to do. So come up with a different solution.
No. I think we could come up with different solutions, and we'd be happy. Child advocates were not, it'd be great to work with everyone to find a bill with child advocates sort of involved in the initial drafting. I'm not actually seeing these cases, and I haven't actually heard of the specific cases where that is happening, right, where children are being removed solely because they witnessed domestic violence. Like, despite the presentations you heard, I have not heard of specific cases where that is happening.
Let me throw an extreme example. And this would be extreme, but this is what it would allow. You have we use a mom who has a child and has a boyfriend who doesn't live with her but stays a lot and abuses her, beats her a lot. And under the current scenario, DSS can come in and it could make a finding of neglect. It could say you need to get out of this relationship or take some other steps to make sure this doesn't happen and doesn't expose your child. And this person doesn't make that happen. The DSS then could start a process, which is not an easy process, because a finding of neglect does not necessarily equal removal. There's a lot, as Mr. Perry identified, a lot that has to go on. With this bill, DSS can't do anything. They're done. They're screened out. They have no jurisdiction over this. They can't provide any services. They can't do anything. So this mother is consistently with this child. There's no help for her. There are no services, and quite frankly, there's no stick, if you will, a fear of that the state may in fact take her child away if she doesn't extricate herself from this toxic relationship that is damaging her children. We've lost all of it.
But that's not neglect. She's not neglecting the child by staying in the relationship. There's other reasons.
That's neglect. Her failure to prevent the child being exposed to domestic violence is the neglect. That is neglect. That's the point we're making.
Okay. All right. Thank you. I got it. I understand.
Okay. Thank you.
May I add, I guess, one brief
currently. Sure. Go ahead, Mr. Perry.
Oh, there's an important principle in child in need of assistance law that we do not wait for children to be harmed, that the goal of SINA law is to prevent harm. This bill, I think, would risk undoing that important principle, in that, it would, even if under an interpretation of this bill that you could help children who have actually been injured. And again, it's not clear to me that the bill allows that interpretation, but this bill would basically say that you have to wait for the child to be actually injured, which would again be a fundamental reversal of an important principle of SINA law.
Delegate Cox.
Thank you, Mr. Chair and panelists. Quick question for Mr. Griffin. In your view of neglect, if one parent regularly screams and yells, would that potentially rise to the level of neglect such that the other parent that does not scream and yell could be charged for that scenario?
I think, we can give all kinds of examples. I can't ever recall.
It's a simple question.
No, I don't think, I guess an extremist, yes, you certainly, but 99.99% of the cases, I would say no, it would not rise to the level of neglect. I guess if someone is so emotionally abusive, in an extreme sense to the other adult, that could possibly be, but I can tell you, I've never seen or heard of a case like that in 20 plus years of doing this type of litigation.
Well, as you know, in the 400 years of common law history, we don't always, and we never have held people accountable for other people's actions. And that seems to be what you're advocating. So it concerns me greatly, but thank you.
Thank you.
Are there further questions for the panel? Seeing none, we thank you all very much. And that concludes the testimony for House Bill 338. Now, we're going to House Bill 294 and Delegate Crutchfield. Several witnesses in this case, and there are several set panels to begin. We'll hear from Delegate Crutchfield, John King, Jenny Egan, Kimberly Watts. Is that it? Devon Williams. We'll hear them in the first panel. Delegate Crutchfield will get 3 minutes. Everybody else will get 2. Delegate Crutchfield, please begin.
Thank you, Chair. And good afternoon, Vice Chair and colleagues. For the record, I'm Delegate Charlotte Crutchfield. I represent District 19 in Montgomery County, and I want to give some testimony in support of HB 294. This legislation will change the trajectory of children's lives by eliminating the statutory requirement to automatically charge children as adults for certain charges. Right now, children as young as 14 years old can be automatically charged as adults, with charges, if committed by an adult, will be life in prison, or children who are 16 years or older can be charged as adults for a list of 33 statutory crimes. What does this mean for a child? Well, it means confinement in adult prison, where sometimes you may languish as long as 155 days until you're transferred to juvenile jurisdiction. This means your education is disrupted. You may not receive the services needed, such as mental health and also medical treatment. If you're a Black child, you may be more likely to be charged as an adult because over 80% of the children charged as adults are Black children. You may suffer from physical and sexual abuse. You may become a repeat offender and commit more violent crimes in the future. All this bill does is start children out under the jurisdiction of juvenile court, where a judge who has training and experience can review and consider all relevant factors, and at their discretion determine where a child should be charged for an offense. This does not remove the prosecutor's ability to petition a juvenile court to waive its jurisdiction over any child. Children are put on track for rehabilitation and not punished in the juvenile system. You will hear from panelists who will describe in more detail about the brain science, trauma, and other reasons that all proceedings against children should be initiated in juvenile court jurisdiction. Please listen carefully. We must overhaul our juvenile justice system. We cannot continue to treat our children in this state in this manner. They deserve rehabilitation, care, and not punishment. We have the power to make that change. For these reasons, I urge a favorable report on House Bill 294.
John King for 2 minutes.
Thank you, Mr. Chairman. My name is John King, and as someone who became a teacher, principal, and Secretary of Education for President Obama only because I was given a second chance as a kid, I'm here today to implore you to support House Bill 294. Like many of the young people who are automatically charged in adult court, my story began with trauma. When I was a kid, both my parents passed away by the time I was 12. My mom when I was 8, my dad when I was 12. In between, I lived with my dad who was struggling with Alzheimer's. Home was incredibly unstable and scary. And I struggled. I struggled as a teenager, like many teenagers who've experienced trauma. I made bad decisions. I actually got kicked out of high school. But my life was saved by teachers and a school counselor who are willing to give me a second chance, who are willing to see me as more than the sum of my mistakes. If instead I had been funneled into a criminal justice system like ours today in Maryland, I would likely be in prison or dead today. Those are the stakes of this issue. As Senator Kelly points out, year after year, no one is born bad. The kids who get in trouble are just that, kids who, like me, have experienced trauma, kids who have had adverse childhood experiences, who've been left behind by a society that too often ignores their needs. While this does not negate accountability, it does mean we must have real rehabilitation, real justice. That means education, mentoring, mental health services. Our state's current approach to young people who have made mistakes ignores the data and scientific evidence that leads to better public safety outcomes, and instead has led Maryland to the highest rate of incarceration for young Black men in the country. It doesn't have to be that way. We owe it to our kids and our communities to do better. For those reasons, I urge a favorable report on HB 294.
Okay. Jenny Egan for 2 minutes, please.
Thank you, Chair. Thank you, Delegate Crutchfield, for introducing this important legislation. I'm a juvenile public defender in Baltimore, which means I sometimes get accused of not caring about the terrors of interpersonal violence. I want to let this committee know that it is a life-warping experience to attend the funeral of a child you love. I have done so many times over. Rest assured, I am mired in violence and I am sick with it. I am here to advocate for these reforms, not because I don't care about public safety, but because that is all I care about for young people. The good news is that these recommendations come from the Juvenile Justice Reform Council, where we learn from experts across the political spectrum and across the country that we know how to respond when young people make mistakes. Treating young people improves behavior, improves outcomes, and most importantly, it reduces future crime. The data and evidence told the JJRC 3 things very clearly. One, that young people make mistakes, sometimes trivial and sometimes terrible, because they are young, not because they are some form of heartless or sophisticated criminal. 2, punitive solutions make things worse. Incarceration without intervention turns corner boys into robbers, turns robbers into trigger pullers. And last, but certainly not least, rehabilitation works, and it works better for young people. These things are true because the thing that leads young people to commit more crimes, immature brain development, impulsivity, short-term thinking, susceptibility to peer pressure, is also what makes young people more open to positive change. Brain plasticity means that how we as a state respond to a child's mistakes, even the most dire, is the thing that matters most for how that young person will behave in the future. Youth charged as adults who were transferred down to the juvenile system in Maryland have a reincarceration rate of only 17%, compared to 40% recidivism rate for those who are sent to Maryland's adult prisons. I want to emphasize for this committee that this bill does not end the ability to have youth tried or sentenced in adult court. It only affects where their cases start.
Ms. Egan.
It still ensures every case starts in juvenile court until a judge gets to look at the factors, the unique circumstances of the young person, and the context of the crime to decide whether a young person is amenable to treatment in the juvenile system.
All right, thank you. We'll go now to Devon Williams. No. Go to Kimberly Watts, please, for 2 minutes.
Thank you all. I'm an attorney offering this testimony on behalf of my client, Andrew Zaragoza. He's currently in DOC's Patuxent Youth Program and has no internet access. I was 16 years old when I was arrested for killing my mother. I loved my mother, but she was mentally ill and addicted to drugs. My dad died of an overdose when I was 15, and things got worse after that. When she was high, a lot of times I woke up and she was climbing on top of me. About a month before, CPS came to the house, but they never talked to me alone, and so I couldn't tell them about my mom. I tried to spend as much time as possible away from home. I was in 11th grade and in honors and AP classes. I wanted to move out of my parents' house and go to college. I had never been in trouble with the law before. On the night I killed my mother, she was high. She started molesting me, and I told her I was calling CPS. She stabbed me in the chest, and at that point, I fought back. I didn't mean to kill her. I just wanted her to stop, and I was afraid she was going to kill me. When I realized what I had done, I tried to kill myself. I texted goodbye to a few of my friends, one of whom called the police. I was taken to the hospital and had surgery. I woke up handcuffed to the bed by one arm with the IV in the other, and both of my ankles were in shackles. When I got locked up at first, I felt lost. They put me in a padded isolation room for 14 days because I was suicidal. I was very mentally shut down. The depression was so bad that it was killing me. I just felt sadness, grief, and anger. Even after I was off isolation, I was still in a cell alone for 23 hours a day until I turned 18. Being on 23andMe was mental agony. It's more than just being bored, and I spent 18 months on 23andMe. I was never allowed to have a transfer hearing, and it felt unfair that I never had a day in court to prove that I was a juvenile and that I could be rehabilitated. I think I can still have a bright future, but being charged as an adult has made that a lot harder. I'm blessed that I have support. I see other people here who don't. They're not getting what they need, and they're getting lost. Being here isn't helping anybody. It's just making things worse.
Thank you, Ms. Watts.
Thank you.
Devon Williams, please.
Good morning. My name is Davon Williams. I'm 19. I'm here to speak on the behalf of my own experience and also my peers. I feel as though as a young generation, we shouldn't have to worry about being charged as an adult. Children should not have to be concerned with interacting with the adult court system. We all was kids once, and we have made mistakes. So there are children who will make mistakes, who are still developing and deserve the room to make mistakes, and the system is supposed to be designed to support them. I feel children and the adults who care for them should be provided with more resources that can help reduce behaviors that the legal system deem as problematic. This reduces their interactions with the juvenile legal system, but most importantly, the adult criminal system. I strongly feel this bill will help push in the direction of seeking resources such as mental health, special social welfare mentorship, and other things that are important for the development of young folks, instead of pushing and disciplining them into a system that is violent and, again, not designed for young people or their experience as minors, but to help them understand the basic needs of how to go about everyday life. I personally know kids who give up on trying to be something in life just because of the things they go through in the adult system. There are kids who are being sent away for years instead of helping understand who that kid is and why they do the things that they do. People ignore them and put them in a box with their personal thoughts for 23 hours and expect them to be okay. This is why I support the bill, and I feel as though we all should too.
Thank you very much. I believe that concludes the first panel. We'll go now to questions. We'll hear first from Delegate Shoemaker, please.
Thank you, Mr. Chairman. I guess this is for the sponsor. Yeah, we've heard quite a bit about concern over juveniles going into the adult system. What about the victims, though? I mean, we're talking about crimes of violence here, including rape and murder. I mean, shouldn't we be more concerned about the victims of those types of very serious crimes? I mean, could you respond to that?
Thank you, Delegate Shoemaker. This bill is about children, okay? And this bill is about starting children out in a place where judges who have experience can make decisions about where they should go next. And so those kinds of factors, including what you described as far as victim impact statements, et cetera, will also be taken into consideration when those decisions are made. I'm not sure if anyone else from the panel might want to make a comment. I'm not sure if Ms. Egan or Ms. Watts.
I can address that, or Ms. Egan can.
Thank you, Delegate Shoemaker, for the question. I will say that on the Senate side, we had some victim rights advocates testify who just weren't available today. So I can point you towards that testimony. But in addition, complaining witnesses and victims often do support more rehabilitative measures for young people, and automatic charging means that those decisions and their input are not heard at all. This bill doesn't stop kids from being charged or from being tried or sentenced in adult court. It only requires that the court decide which children go up to adult and which children stay in juvenile. This would actually give complaining witnesses who want rehabilitative measures a voice and input into where that child's case will go. In addition, I would also argue what we hear a lot from complaining witnesses is that they want young people to be accountable, but they don't want them necessarily to go to prison. And this allows a judge to get to make those decisions instead of just the bare charges without any context or any input from the complaining witness.
Well, just to follow up on what you just said, you would acknowledge, wouldn't you, that if the ultimate goal here, I guess, is rehabilitation of these young folks, that, I mean, one could get more of an opportunity for rehabilitation in the adult system, couldn't they? Because, you know, you could get up to 5 years of probation in adult court. Isn't that right?
So Ms. Watts read testimony from Andrew Zaragoza, who, because he was charged at 16 with murder, was not eligible for a transfer hearing. He testified, and his testimony was that Patuxent is not providing services. So I'd have her address that. But no, just frankly, no. You can look from our written testimony. The adult system does not provide rehabilitation. It's not built for rehabilitation. Even the Patuxent Youth Program is not actually for young people, and not all young people who are made eligible are allowed to go to it. The juvenile system just has intensive amounts of services, from family therapy, from families. That's one of the major differences, is that from the minute a petition is filed in juvenile, the parents and guardians of that children are parties to the matter. The court can order things controlling conduct for parents and families that are not options in the adult system. And we know so often that when children go astray, it is a whole family that is going to need tools and treatment to improve the long-term outcomes for children. But absolutely not. The juvenile system has rehabilitative measures, has therapy, training, education programs that are not available in any way, shape, or form in the adult system. That being said, this is not about where the kid is sentenced. This is only where the case starts. Right now, 9 out of 10 kids charged in adult court don't end up with a criminal conviction. So we're wasting a huge amount of resources before we even get to the question you're asking, which is more about where the child is tried and sentenced.
Just one other question, Mr. Chairman, for the sponsor, if I could. Now, Delegate Crutchfield, you would acknowledge, wouldn't you, that even Brian Frosch, who I'm here to tell you is no Barry Goldwater, even he has opined against having murder and rape start in juvenile court, hasn't he? Do you care to comment on that?
You know, the Attorney General has supported this bill, okay? And I think the thing to understand again is that the biggest piece of this bill is just where it starts. I mean, children should be rehabilitated. And I would say that even though the Attorney General has mentioned some areas that he's concerned about, overall, it sounds like he supports what we're doing here. And that is to rescue our children, okay? To rehabilitate them, to give them the success that they need. And that means education, that means all kinds of medical treatment, that means to make sure that they are successful, they are rehabilitated, and they will never get that in the adult system. Not with being, in fact, you heard from Ms. Watts and her client, who is confined in solitary confinement for 23 hours out of the day. That is disgusting, that we are allowing our children to be like that.
And if I could provide some further information for Delegate Shoemaker. First, let me say, as someone who actually has been the victim of a crime by a juvenile who was also a juvenile charged an adult, my crime was a burglary, but he also stole a gun. And so that wound up being starting in adult court. I can honestly say to you that it was terrifying to have a stranger in my home, but I also wanted that kid to be in a better place. I want to live in a safe community. I want to be safe. And I know that emotionally that was difficult for me, but rationally, when I stepped back and looked at things rationally, I wanted that kid to get the treatment and rehabilitation that he needed. And I know I'm not alone when I say that. What I can also say about the services available to adults is that even when you look at the 5 years of probation that kids can get, adult probation officers are not equipped to help kids who don't have driver's licenses or any means of self-support to fulfill their probationary conditions or get rehabilitated, honestly. When you look at the kids who are in the Division of Corrections, they have no educational opportunities aside from a GED. They're supposed to have these modules for rehabilitation in the Patuxent Youth Program, but I can tell you my client, and I know I have other clients that have been there as well, has been there for 2 years and has been asking for these modules and has yet to get them. He has no infractions. When I've talked to his case managers, they can't give me a reason other than it just takes time. So I would say that starting in adult court is really failing our children. Thank you for your time.
Thanks.
Are there further questions for this panel? Seeing none, we thank you all very much. We'll now go to Marlon Tillman, Josh Rovner, Howard Meganson, James Dold, Michael Mendoza. I think that's it. That is it. Okay, we'll take that panel and then we'll take more questions. Mr. Tillman, Marlon Tillman, please.
Yes, sir. Yes, sir. Good afternoon, Chair. How are you today?
My name's Nina DeYoungi. I'm the policy.
All right.
Go ahead for 2 minutes.
Yes, sir. Chair Clippinger and Honorable House Judiciary Committee, I'm speaking on behalf of Bridge Maryland Incorporated, a nonprofit faith-based organization with one primary function: to raise the consciousness of Maryland on the great work you all have done, and as your partner will continue to do. This is why Bridge Maryland supports House Bill 294. This bill addresses one simple fact: children and youth are not adults, and we should have the empathy to know and treat them differently. Maryland sends more young people per capita to adult court based on offense type than any other state except Alabama. Is that the message we want to send to our children? Our sacred text says, train a child up in the way he or she should go, and when they are old, mature, they will not depart from it. When we introduce a child to a more aggressive and mature judicial system, ill-equipped to address the needs of children, we are forcing children into adulthood too soon, and thus creating a traumatic event that scientifically increases their likelihood to reoffend sooner and more violent crimes pursued if they are not charged in juvenile court. We are better than this, and we must treat our children better. Maryland should join the 26 other states who have passed laws to treat children like children and end automatic charges. Bridge Maryland urges this committee to issue a favorable report on House Bill 294. Thank you for my time.
Josh Rovner, please, for 2 minutes.
Thank you. My name is Josh Rovner, and I'm a resident of District 18 and Senior Advocacy Associate at the Sentencing Project. This legislature unanimously created the Juvenile Justice Reform Council to study the flaws in Maryland's youth justice system. After months of expert testimony, the JJRC endorsed ending automatically charging youth as if they were adults based on the offense. The resultant bill is the one we're here to talk about today, and we endorse it strongly. Maryland's current transfer process is rife with flaws. Compared to other states, having a list of 33 specific charges is incredibly unusual and contradicts the advice of experts, such as a panel at the National Research Council, who reject the way that Maryland does business. Indeed, decades of research, including a compendium from the Centers for Disease Control and Prevention, have shown that the youth charged in the adult system are more likely to reoffend than similarly situated peers in the juvenile system, and even worse, that their next arrest will probably be for a more serious crime. In short, this bill is good for public safety. With such a long list of charges, it's not surprising that, as you heard, Maryland automatically transfers more of its children into adult court than any state except one, Alabama. Overwhelmingly, nearly exclusively, they are youth of color. The status quo sends hundreds of teenagers into adult courts to wait for a process that will dismiss the charge entirely or wave the children and adolescents back into the juvenile system more than 85% of the time. It's an astonishingly inefficient system. This bill would start all of their cases in juvenile court. That's already the law in 9 other states, a list that includes Texas, Tennessee, Kansas, and Kentucky. This bill, like theirs, still allows our children and teenagers to be waved upwards into adult courts. It simply requires a judicial hearing before doing so. That's a matter of fairness, and we urge the committee to vote on this bill as written as soon as possible. Thank you.
Thank you. Howard Megginson, please. Howard Megginson. He's here. Howard Megginson. We'd ask him to unmute, please. All right, we'll come back to him. James Dold, please. 2 minutes.
Thank you so much, Mr. Chairman. Members of the committee, my name is James Dole, for the record, representing Human Rights for Kids. I want to first start off by thanking Delegate Crutchfield for introducing this important legislation. One of the things that's unique about Human Rights for Kids is that we have a board of directors that's made up of current and former state legislators from around the country. We have 6 Republicans, 5 Democrats who serve on our board, including Baltimore County Delegate Dana Stein, who's a former mentor of mine when I was an intern in his office many years ago. Also on our board, we have former law enforcement officers as well as victims of crime. We've all come together to advocate on behalf of some of the most vulnerable children in our criminal legal system, and we're here to testify and support today on this important legislation because automatically sending children to adult court is a human rights abuse. It's a violation of basic international human rights norms under the UN Convention on the Rights of the Child, and something that is still, unfortunately, a shameful practice in many parts of the country, and especially here in the state of Maryland. I want to talk about who these kids are briefly, because I think oftentimes we have this tendency to look very diametrically at victims and offenders. But the reality is, and there was a lot of discussion in the last piece of legislation about adverse childhood experiences. The reality is that what we see with the vast majority of kids who come into conflict with the law is that they are contending with extreme amounts of violence in their communities, in their homes. They've witnessed domestic violence on a regular basis. They've been victims of abuse and neglect. What we see with girls in particular is about 73% of them were victims of sexual abuse before they entered the system. And this is very important context for understanding how and why kids come into the system and what we need to be doing on the front end when we're considering whether or not it is appropriate to send them to adult court, right? So oftentimes when we have this conversation about automatic charging, the conversation goes in the direction of, well, what about murder? What about the most serious cases? And many of you might be familiar with some high profile cases, that of Sarah Cruzan or Centoya Brown or Alexis Martin or Patrice Smith. Each one of these girls I just mentioned was a child sex trafficking victim who killed her rapist or abuser. And because of automatic transfer laws, they were automatically charged in adult court and given lengthy prison sentences. It took an act of the governor stepping in to finally bring justice, some sense of justice to their cases. That is why this is so important. And folks might also be familiar with the case of Kyle Rittenhouse. I know that his case has been very has invoked a lot of passion on both sides of the aisle. But I will
Mr.
say,
Gold,
yes.
Gonna need you to wrap it up.
Wrap it up? Okay. But even for him, who is a child, it is important that judges always consider the particular facts and background of every single child who comes into the system. And that is why we're here to testify in support of this. If you support victims, if you care about victims of crime, you have to also care about the kids in our system. And it's important that judges make these determinations at the outset before sending a child to adult court. It is a human rights issue. Please support this important
Thank you very much.
Thank you.
Michael Mendoza, please, for 2 minutes, then we'll go back. Michael Mendoza.
Thank you, Chairman and all members of the committee. My name is Michael Mendoza, and I'm the Director of Advocacy with the Anti-Recidivism Coalition. And I thank you for this opportunity to speak in support of this bill. This bill is very important to me because at the age of 15, I made the worst decision of my life and participated in a gang-related murder that unfortunately took the life of another young man. I was immediately arrested and held accountable as I should have been. However, I had never felt so hopeless standing before a judge and being tried as an adult convicted to life in prison, feeling as if the whole world had given up on me and that I would never go home. Young people in adult prisons face sexual, physical, emotional, and mental abuse. Most never make it home. I was more worried about my safety than rehabilitation. And by the grace of God, policy saved my life and allowed me to prove that I wasn't that 15-year-old kid anymore. This bill recognizes that children are developmentally different from adults and should not be treated like kids in the criminal justice system. Instead, children need age-appropriate services. More importantly, this bill will save lives and make families healthy and whole. For these reasons, the Anti-Recidivism Coalition supports HB 294, and I respectfully urge this committee to issue a favorable report. Thank you.
Thank you. Now we'll go to Howard Megginson for 2 minutes, please. Mr. Megginson, please.
Yes, sir. I'm here. I'm here.
2 minutes.
Okay. Good afternoon, members of the committee. My name is Howard Megginson. I was 16 years old when I shot a guy in my neighborhood one time, forever changing his life. I'm so sorry for what I've done, for my horrible actions. I was tried as an adult and sentenced to 90 years in prison for attempted murder and sentenced to 90 years. My life was thrown away for what I've done. I was deemed unworthy of ever living in society again. But at the age of 16, I was not an adult. I was short-sighted. I was impulsive. I was a follower. I was a child. I spent my teenage years and adult life raised in prison. I saw things no one should ever experience. No one should ever experience. It didn't cause me to be a better person. Prison does not help anyone become a better person. I became a better person despite prison after spending more time incarcerated than I have lived on this earth free. I was given a second chance and I'm committed to making the most of it. I'm working, I cherish my family, I'm building a life for myself. The law judged me as an adult when I was just a kid. Nothing will ever excuse what I've done when I was a teenager. But I am more than worst thing I've ever did, and at age 16. I was not yet a man. I am today. The law should presume that children are irredeemable, even when they have done may be unforgivable. I ask you to end the automatic charging of children as an adults.
Thank you very much. Are there questions for this panel? Does anyone have a question for this panel? Delegate Cox.
Thank you, Mr. Chairman. I wanted to thank the panelists for your stories. Mr. Mendoza, very heartfelt, everyone. Very heartfelt stories. So thank you very much for your time.
Any questions for the panel? Seeing none, we thank you all very much. Ryan Levy, Brianna Drayton, Nick Maroney, Margaret Berry, Jarrell Frazier, and Donna D'Alessio. Any questions for the panel? Drayton, you're going to need to shut off. You're going to have to mute yourself right now. There we go. All right, Brian Levy, please. Jarrell Frazier and Donna DeLacy. Brian Levy, please.
Thank you, Chairperson Clippinger. I apologize for the technical errors. My name is Brian Levy, and I work as a public defender in Baltimore City. In my current role, I exclusively represent teenagers who have been automatically charged as adults with committing crimes. The automatic charging of children as adults, the status quo that this bill would eliminate, is an unjust and unsuccessful policy. The current system is unjust because it greatly exacerbates some of the most broken parts of our criminal justice system. Just one example, the already problematic plea bargaining system is thrown greatly off kilter when the prosecution holds over a child the threat of sending them to prison for the rest of their foreseeable lives. With that type of leverage in hand, it's not uncommon that prosecutors coerce teenagers whose own lawyers may be convinced they're factually innocent to plead guilty in juvenile court to crimes they may not have committed. The current system is also unsuccessful as it doesn't improve public safety. Look at the data that's been presented to you, look at the research, but also just use your common sense. The teenagers I represent, most of them not only come from great disadvantage and vulnerable situations, but have themselves been subject to immense, often simply heartbreaking trauma. Automatically placing those children in adult prison further traumatizes them. It further disadvantages them rather than rehabilitates them, and it then releases them into a world without the help they need to succeed, leading foreseeably and counter to all of our public safety interests to them reoffending at higher rates than those in the juvenile system. I know some of you may be of the position that some youth are irredeemable, some acts are unforgivable, and it would be better to just put those individuals away for a long time. While I likely disagree with you, it's important to remind you that the changes this law would make will not eliminate the state's ability to send those cases to the adult system. All it does is get rid of the unnecessary, unjust, and counterproductive policy of automatically starting so many of them there. Thank you for your time.
Brianna Drayton, please, for 2 minutes.
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Brianna Drayton. I'm a student attorney in the Youth Education and Justice Clinic at Maryland Carey Law. We represent children who have been suspended and expelled from schools. Many of our clients live at the intersection of school discipline in the juvenile and criminal legal systems. Quite honestly, I was shocked to learn that only Alabama sends more children per capita into adult courts than does Maryland. I had the same reaction when I learned that in 2019, nearly as many of Maryland children were charged in adult court than children in Arizona, California, Pennsylvania, and Massachusetts combined. Unfortunately, between 2013 and 2020, Black children comprise 80% of children charged as adults. The over-criminalization of Black children feeds into the over-incarceration of Black adults in Maryland. While only 31% of the Maryland population is Black, over 70% of our prison population is Black. Studies have shown that Black boys and girls are perceived to be older than their young years. They are seen as less innocent than their white peers. Adolescence is the time in life when youth should explore and find themselves. However, for Black children, this is a time when they are pulled out of their communities and their schools and pushed into the adult criminal legal system. If passed, this bill will allow children to be seen as adults. This bill will allow children to be seen as children at the outset of the criminal process. I ask that you provide this bill a favorable report. Thank you.
Thank you very much. Nick Maroney, please, for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, members of the committee. Nick Maroney is, as stated, for the Juvenile Justice Monitoring Unit. We are an independent state agency based in the Attorney General's office, and we work to prevent abuse and ensure appropriate services in the deep end of Maryland's juvenile justice system. Unfortunately, there's no such unit looking at the adult system. The automatic prosecution of children and young people as if they were adults is a relatively recent practice. It's an invention that came into being in Maryland just in the 1990s. What it does as a practice is take away the balance afforded by court discretion to weigh allegations, charges, and circumstances on a case-by-case basis when deciding whether to subject a young person or a child to the adult criminal system. The vast majority, as we've heard, of youth who are automatically charged as if they were adults do not end up in the adult criminal justice system. But in the meantime, they've been subjected to the risks associated with confinement through the adult criminal justice system, a system that ultimately has been found to be inappropriate for them. The adult prison system entails a high risk of abuse for young people, a high risk of self-harm for those left among adult criminal actors, and offers little to nothing by way of individualized services and supports, despite what some folks think, unfortunately, little to nothing by way of individualized services and support for young people in that system. And that is in stark contrast to the juvenile system, which is centered on service provision. And the Department of Juvenile Services offers individualized services and supports for youth, regardless of the level of charges pressed against them. And let's also not forget that these are charges. This is an allegation. This is not something that has been proved, and already we are pushing those kids into the adult system. If the current bill does become law as is, it will, as also has been stated, not mean the end of prosecuting children in Maryland as adults, but it will mean that the right of a court to examine charges and make decisions based on individual facts and circumstances is reinstated. And then rather than having an automatic decision based on a type of charge or an allegation, prosecutors will need to offer arguments to support turning a young person over to the adult criminal justice system.
Mr.
For all of these reasons, thank you. For all of these reasons, the JJMU, the Independent Monitoring Office, supports HB 294 and respectfully urges the committee to give the bill a favorable report. Thank you.
Margaret Berry now for 2 minutes, please. Margaret Berry for
Yes,
2
I'm
minutes.
right here. Thank you. And
Great.
good afternoon. I'm Professor Margaret Martin Barry, speaking as a member and on behalf of Montgomery County Women's Democratic Club. Passage of HB 294 is a priority for WDC, and we've also submitted written testimony. Automatically charging children as adults is contrary to our obligation to protect their best interests. This obligation is reflected in the very existence of our juvenile courts. And that obligation, when it comes to even the most violent acts by children, calls for us to treat them in a manner that looks to care and rehabilitation, not to harsh punishment and abandonment. Indeed, research has shown that placing children in the adult system can cause serious damage, as others have mentioned, such as increased risk of suicide, harm to identity formation, physical and sexual abuse at higher rates, placement in solitary confinement, often for their own protection, without regard to the suffering and mental health implications, and contrary to United Nations standards on torture. You might think we push children into the adult system because of the resulting societal benefit. Studies have found no deterrent effect or other punitive benefit in treating children as adults. Furthermore, automatic charging disproportionately harms our Black children. Using 2019 data, the Office of Legislative Services calculated that Black youth in Maryland were over 7 times more likely to be criminally charged as adults than their white peers. And sentences imposed on these children were found to be harsher. Judicial precedent tells us, the science tells us, social research tells us, common sense tells us that we can have a far better chance of effectively addressing crime committed by children if we treat them as children. Automatically imputing adulthood is as harmful as it is ineffective. We're heartened that the Juvenile Justice Reform Council recommends this change, and we thank delegates Crutchfield and Moon and other sponsors of this for their leadership. We urge you to vote for a favorable report of HB 294, and thank you.
Thank you. Darrell Frazier, please, for 2 minutes.
Yes, sir. Thank you. Good afternoon, Mr. Chair, Vice Chair,
and members of the Judiciary Committee. My name is Darrell Frazier. I had the pleasure of serving as the Policy and Community Engagement Manager at the Mental Health Association of Maryland. We appreciate the opportunity to present testimony in support of House Bill 294. As it has already been stated, House Bill 294 provides due process protection to Maryland's children by requiring that all criminal cases involving a minor begin in juvenile court, not adult court. Growing up as an African-American male in Baltimore City, I have firsthand been able to experience both the juvenile criminal justice system. Starting kids in the adult system and then returning them back to the juvenile exacerbates trauma and recidivism. Currently, only 9 states send more than 200 kids to the adult court every single year. When we lock up young people, they are more likely to be exposed to extreme violence, fall prey to abuse, and suffer from illnesses. Even if young people manage to escape direct physical abuse in juvenile or adult facilities, exposure and proximity to violence in and of itself causes trauma. The data shows it. 80% of the kids are Black, and 87 of those cases do not result in adult criminal conviction. Racial and ethnic minority has less likely access to behavioral health services than their counterparts. They are less likely to receive needed care, and they are more likely to receive poor quality care when they are treated. Troublingly, although this results in a desperate minority criminalization, incarcerated people of color are less likely to be identified as having a behavioral health disorder and are less likely to receive treatment. And for those reasons, the Mental Health Association supports House Bill 294 and urge a favorable report. Thank you.
Donna DeLessio, please. Donna DeLessio.
294 and urge a favorable report. Thank you.
There's Donna DeLessio. Can you hear me?
I can.
2 minutes, please.
Thank you. My name is Donna DeLessio. I'm also an attorney with the Public Defender's Office, and I've been representing children in charge as adults since 2004. I believe this is a reasonable bill, and I would like to direct my comments to those of you like Delegate Shoemaker who are concerned about the cases involving serious crimes like murder and rape. The reason this bill is reasonable is because what it will do is allow the judiciary and the juvenile system to target narrowly those juveniles whose cases actually merit prosecution in the adult system. It will do this, as you've been told, by beginning it in the courts and allowing a judge to decide which cases go to adult court and which cases should stay in juvenile court. 87% of the children charged as adults have cases that do not result in adult conviction. Yet those 87% have already been exposed to and traumatized by the adult system. Who are those 87%? Well, because the system currently is based on charging, a lot of those 87% are children who were overcharged from the beginning. For example, police officer charges a child with first-degree assault. That child automatically goes to the juvenile system if that child is 16 or 17, to the adult system, sorry, if the child is 16 or 17 years old. But first-degree assault is overcharged so often that 95% of the youth who are charged with first-degree assault do not end up with convictions in adult court. Now, those individuals who are charged with murder, rape, and other cases like that are not, if the bill were passed and they were started in the juvenile system, they would not be out on the streets creating a danger to the public. They would be detained until a judge decided that their cases warranted the adult system. So there would be no additional danger to the public. And what we would be doing is protecting those 87% from having the trauma of going through the adult system. Now, what happens
Ms.
to that?
DeLessio,
Yes.
I'm going to need you to wrap up, please.
Thank you. Thank you. So to wrap up, I would just say that the present system we have now, the default is the adult system. We need to protect those children who shouldn't be there. And at the same time, we're protecting the public from those who will end up in the adult system through the waiver process. Thank you.
Thank you very much. We'll now take questions from the committee. Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in. I think it's Alessio. I hope I said it right. But Miss Donna, did you submit any written testimony on this overcharging of the juveniles?
I did not myself, but the Office of the Public Defender has.
So that should be in there. And would you have any comment as to how many of the juveniles that are charged and they move them up to adult have educational ability to understand what it is that they are accused of?
Educational ability to understand what they're accused of?
Sure.
You mean whether or not they're being overcharged?
No. In other words, if a person is just because they're 18 years of age, they might be on a 12-year-old reading level or something, and not be able to comprehend the fact that what they did was not a video game, but was something that really happened. It's reality, and then it extends beyond just they shot the person. Now the family is grieving. There's other medical bills. They don't understand the total situation. Do you have any comment on something like that?
That is true. I mean, there are plenty of individuals who are over the age of 18 who end up also being in a system that they don't understand. And, you know, we don't have at the current time any way of putting them in the juvenile system, but we do have courts, and it is up to us to try to advocate in sentencing to account for their learning differences. However, if that same child is 17, then we do have the ability to keep that child in the juvenile system. And that's what we're asking to do in this bill.
Okay,
Maybe later.
Thank you so very much.
Thank you.
Further questions for this panel? Seeing none, we thank you all very much, and we'll move to the final panel of supporters. Crystal Williams, Phil Karoon, Melissa Goman, Laura Stewart. And then we'll have the opponents. So if we could begin, please, with Crystal Williams. Crystal Williams, I see you. Go ahead for 2 minutes.
Afternoon. Yes, good afternoon. My apologies. My name is Crystal Williams, Director of the Government Relations Division for the Office of the Public Defender. This bill is a necessary piece of reform for improving our justice system and overall public safety for everyone. When addressing smart reforms, we simply cannot focus on statistics outlining the problem. We must look at the proven data and research supporting actual results for reduced recidivism. And we must start by asking, why are children engaged in dangerous activity? Treating them as adults does nothing to answer that question or prevent it from happening. Rather, it has long been proven that transfer laws increase crime and recidivism. As an attorney in Baltimore City, I've represented kids who committed serious offenses ranging from murder to selling drugs. I've also represented kids who were star students arrested and detained for getting into a fight at a basketball game, which resulted in a first-degree felony assault subject to 25 years incarceration. Automatic charging sweeps all kids into a system that is neither designed nor equipped to address their developmental needs as a child. These children in adult facilities are subject to invasive strip searches by adults, to horrific violence by adults, and damaging conditions of solitary confinement, deprived of their education and mental and physical health services, in addition to being bullied out of costly phone calls to their loved ones and basic necessities like food, socks, underwear from older inmates. Many of my clients have gone weeks without showering, either out of fear or mismanagement of the facility. We seem to all agree that children must be treated as children, even at 16 and 17 years of age, if they are viewed as a victim of abuse. But we have yet to recognize that that same child, sometimes as a result of being a victim with untreated trauma, may commit a criminal offense. We encourage laws like this not simply to minimize the impact of crime on victims, but to prevent all persons from being victimized and to not negate the trauma of all victims. Children who commit horrible offenses oftentimes have had horrible and unspeakable things happen to them. I represented clients who have been sexually abused, physically beaten, and left in abandoned houses with no food, electricity, or supervision, and who grew up watching their parents suffer with addiction and sometimes witnessing their death. These children are suffering, and that suffering can manifest into destruction. When asking my clients why they did what they did, in addition
Ms.
to
Williams?
yes, if I may briefly conclude.
That's
In
fine.
addition to telling me that they need a job, they often tell me that no one cares about me, so why should I care about them? This answer shows that we have failed them. All kids need to know that we care about them and their futures so that they care about themselves and their futures as well as their fellow neighbors. We need to understand that 95% of youth sentenced as adults will return home by their 24th birthday, and 85% of them will be home by the time they are 21, which means that's time that can be spent receiving rehabilitation in our juvenile justice system that extends to the age of 21 years of age. We know rehabilitation works, and rehabilitating children is a positive public safety policy we should all support. Thank you.
Melissa Goman, please.
Thank you, Chair and members of the committee. My name is Melissa Goman, and I'm the Senior Policy Counsel at the National Juvenile Justice Network. We're here in support of HB 294. Charging youth as adults is a serious and often a life-altering decision, so it requires serious consideration by a judge. This step is essential because the negative ramifications for the young person and for public safety are many. As other witnesses have said, youth held in adult facilities are at much greater risk than youth in juvenile facilities of physical and sexual abuse, mental health deterioration, and suicide. They're also less equipped to re-enter society after serving in adult prisons because they're not provided with appropriate general educational programming or special education services, which many of them need. Additionally, an adult record leads to collateral consequences, including greater difficulty being able to get a job and access higher education. So all of this leads to a direct negative impact on public safety. Research shows that youth tried as adults have higher recidivism rates. A CDC report has stated, and I quote, "To the extent that transfer policies are implemented to reduce violent or other criminal behavior, available evidence indicates that they do more harm than good." And finally, automatically charging youth as adults exacerbates the already significant racial inequities in Maryland's criminal justice system. The national tide is understandably turning away from automatically charging youth in adult courts. We've gone from auto charging approximately 15,000 youth per year nationally to under 10,000 per year over the past decade. So we urge you to join this movement in favor of ending automatic charging and to support HB 294. Thank you.
Okay. Laura Stewart, please, for 2 minutes.
Good afternoon. My name is Laura Stewart, and I am speaking on behalf of Free State PTA, which represents over 35,000 volunteer members and families in over 500 public schools. Free State PTA submits this testimony in support of HB 294. State juvenile courts with delinquency jurisdiction handle cases in which juveniles are accused of acts that would be crimes if adults committed them. Free State PTA firmly believes that any effort to improve the safety of our nation's youth and our communities must be comprehensive, and this includes the appropriate court system in which juvenile cases can be heard. There are multiple advantages to expanding the jurisdiction of a juvenile court. Trying juveniles in a juvenile jurisdiction has a greater likelihood of providing juveniles with needed services. Free State PTA supports robust education programs to teach students, parents, and community members about violence prevention. Transferring juveniles into adult court minimizes parent involvement. If one is an adult, they are treated as such, and parents have limited rights to advocate for their child. Additionally, more youth of color go into the adult system in the United States than other groups. Hence, there is a concern of equity of over penalizing youth of color within the juvenile justice system. Free State PTA encourages the Maryland court system to implement policies and practices that are reflective of this understanding and its relationship to institutional racism and how it affects the well-being of children of color. Lastly, HB 294 strikes a balance of repealing certain reportable offenses to the local superintendent and school principal, which promotes youth and community safety. Therefore, Free State PTA recommends a favorable report on HB 294. Thank you.
Are there questions for the panel? Seeing none, we thank you all very much for speaking with us today, and that concludes the testimony of those testifying in favor of the legislation. We'll go to the opponents now. Gavin Potashnik, Steve Kroll, Alan Culver, Edward Coyne, Vince McAvoy. Hear first from Mr. Potashnik when he gets on the Zoom. Gavin Potashnik. Great, I see Gavin Potashnik. Mr. Potashnik, if you're ready, please, for 2 minutes.
Thank you, Mr. Speaker, Mr. Vice Chair, Mr. Chairman, Mr. Vice Chair. Yes, it's been a long day. Gavin Potashnik, the Deputy State's Attorney for Hartford County and also representing the MSAA. We are in opposition to this bill. Our chief complaint with respect to this particular bill is one of process. I think the committee is getting the impression that all you have to do as a prosecutor is simply waive a child and the judge will make the decision, so we're all good. I'm here to let the committee know that a waiver and a transfer are two distinct, separate types of proceedings. I have been practicing juvenile law for many, many years, both as a prosecutor and also in private practice, and I have done many waivers and many transfers, and waivers are very, very difficult to win as prosecutors simply because, not necessarily the burden, but because the standard and also because of the problem of trying to address that standard. The standard in a waiver is whether or not the child is an unfit subject for rehabilitative measures. The burden is on us to prove that that's the case. The Davis case makes it even more difficult because it's all on amenability, at which point then in any case where you have a serious case, I'm not sure how a judge can necessarily overcome that burden if the Department of Juvenile Services or somebody else shows that there's at least one service or a multitude of services that youth could benefit from. So it becomes very difficult to overcome that. This presents kind of a problem because specifically with the Davis case, we would have a dynamic where we'd have very serious cases that potentially could result in various serious charges with very serious kids remaining in the juvenile system, which we all know has limitations. The juvenile system only has jurisdiction up until the age of 21. So you're not going to have a long-term rehabilitative measure, which could be necessary because the tap turns off. Additionally, the Department of Juvenile Services does not have as many services for those kids over the age of 18 as everybody thinks. So for those reasons, we want the committee to be informed in terms of what the process is. I did do a written testimony which lays this out in excruciating detail for all of you to read. I would certainly hope that you read it and be informed with respect to all these processes. However, at this point, as the bill sits, we are in opposition to it. Thank you.
Stephen Kroll for 2 minutes, please.
Mr. Chairman, members of the committee, good afternoon. My name is Stephen Kroll. I'm the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorneys Association. And I've been prosecuting cases since 1984 here in opposition to House Bill as it stands right now, 294. Part of my job is to represent victims and witnesses statewide. So I'm amused by the proponents who say they're pro-victim or witness. This is what I do full time. In doing so, when you talk to the victims and witnesses statewide that I have, most are opposed to this bill when you explain it to them. When you explain Mr. Potashnik's memo and understand what the bill actually is, they are opposed to this bill. This bill gives only a consideration by the trial judge to victims' witness statements. It is not one of the 5 factors. And if you look at a murder or a serious crime, it not affects the family of that particular victim, but at least 30 others. If you look at carjacking statistics in Prince George's County and Baltimore City, since the first of the year, they're up 73%. If you ask victims and witnesses, like I said, that I represent statewide, they are opposed to this bill. And for those reasons, as the bill stands now, on behalf of victims and witnesses, we're asked for an unfavorable report as to House Bill 294. I'd ask you to look at Mr. Potashnik's memo. It will answer most of your questions. Thank you very much.
Alan Culver, please.
Mr. Chair, Mr. Vice Chair, members of the committee, good afternoon. My name is Alan Culver, and I'm the state's attorney for Carroll County. I'm here this afternoon to testify in opposition to House Bill 294 in its current form. Not every crime committed by a juvenile is appropriate to be centered around the rehabilitation of the juvenile. The most violent of criminal offenses committed by juveniles requires a more balanced approach that includes considering the rights of the victims as well as the safety of the community. Numerous mechanisms are already in place to protect juveniles. Age requirements for initial charging, transfer hearings, bail reviews the day after a juvenile is charged as an adult to determine their eligibility to return to the community. And even after conviction, juveniles may request to have their case reviewed to be remanded to the juvenile system. There's a misconceived perception that a large number of juveniles charged as adults are a very young age. However, between 2013 and 2020, an average of 975 juveniles were charged with automatic adult offenses. Of those 975, 95% were 16 to 17 years of age, and 61% were 17 years of age. Lately, there's been a movement to close some of the juvenile facilities, and many of these facilities needed to be closed. However, no juvenile facilities have been developed to replace them. Eliminating adult jurisdiction will cause violent juvenile offenders, who may be more appropriate for the adult detention facilities, to be housed in already overburdened juvenile facilities with other juveniles who will be in danger. Eliminating adult jurisdiction entirely will have a ripple effect across the criminal justice and juvenile justice systems. The juvenile justice system is not equipped to handle juveniles who commit violent offenses and who are dangerous to the community. Whatever the problem may be, there are ways to correct the problem without preventing juveniles who commit murders and rapes from appropriately being charged as adults. I urge an unfavorable report to House Bill 294 in its current form, or request that the matter be tabled for further discussion to see if an agreement can be worked out to allow certain crimes to remain as automatic adult jurisdiction for juveniles. Thank you.
You, Edward Coyne, please.
Good afternoon, Mr. Chairman and members of the committee. My name is Edward Coyne. I'm the Deputy State's Attorney for Carroll County. I started my prosecution career over 21 years ago as a juvenile prosecutor in Baltimore City State's Attorney's Office. I've done numerous waiver and transfer hearings, and Mr. Potashnik explained his memo and his testimony explained the remarked difference between the two. I'm going to focus on the characteristics. The JJRC issued a report that had statistics from 2013 to 2020 on automatic adult offenses. And when you look at that report, 8% of those cases involved murder, either first or second degree. 2.5% of those cases involved rape, either first degree, second degree, or second degree sex offense. Other heinous violence crimes include carjacking, which was 5.8%, and using a handgun or firearm in the commission of crime and violence was only 1.5%. So that 17% amount of crimes are some of the worst crimes that this bill would make start in juvenile. And I disagree. A judge is going to decide either way, transfer or waiver, so that the bill is kind of mischaracterized by the testimony of the proponents that a judge won't decide these things. A judge will decide these things if they're charged as an adult. It should start as an adult. These are adult offenses, and then return to juvenile if the individual characteristics of the offender require it. And this bill placed a lot of faith on the Department of Juvenile Services keeping the public safe, because that's where the charges come through. They come to DJS to decide whether to detain. The police don't get to make that decision. DJS does. And DJS is the agency that currently, right now, for every felony charge, they request, when they send it to the state's attorney's office, they're asking that charge be sent back to them for an intake informal supervision. DJS does not want cases, especially felonies, to come to court. So you're going to ask DJS to be the gatekeeper of these cases when currently, as it stands right now, they're asking for felonies to be returned for a non-court supervision. Can you imagine murder having an informal supervision? I would ask that the committee take an incremental approach, look at individual crimes on those 33 offenses like rape, murder, carjacking, using a handgun or crime of violence, those heinous violent offenses to retain in juvenile, and some of the other offenses, first degree assault or other offenses that the committee thinks don't warrant automatic adult jurisdiction, deal with that. This requires balance. There's a lot of the proponents, they focus simply on rehabilitation. I'd ask the committee to do a balanced approach.
Mr. Coyne.
Yes, Your Honor. Yes, Mr. Chairman. Sorry.
Okay. All right.
And I'd ask for an unfavorable report. Thank you.
No, not necessary to ask for court's indulgence. All right. Let's go. We have several questions. Delegates McComas, Crutchfield, Shoemaker, and Conaway in that order. Delegate McComas. Oh, I'm sorry. We have one more to testify. That's right. We have Vince McAvoy to testify. Let's hear from Mr. McAvoy for 2 minutes, then we'll take questions.
Thank you so much, committee. I appreciate that. I'm sending you all an email right now regarding crime. You know, as I speak to Fatherhood Matters every year to this committee, I highlight that not just CDC and fatherhood.gov and any number of different agencies, not just in America, but around the world, discuss the issue of fatherlessness related to crime. And so, of course, I always urge that we can be proactive. I don't just come down here and say no to this bill or that. I offer solutions. I want that to be recognized. That said, I've been in Baltimore for 30 years. And I get, there's a couple of things that have been mischaracterized. I appreciate the previous speaker addressing that issue. When we talk about this issue about the brain not being evolved, this is bunk. What happens to the other kids that, how come they're not committing crime? This is silly. Racial disparity. I'm in city. I've been held up at gun several times. Knife, things robbed from me. Been put in the hospital, a bottle to the head. Okay, no, when you go ahead and look at this solely through the prism of this poor child, remember that harm is happening. What level of assault and what degree of first degree assault has to happen before we don't basically just wipe these things away? Fourth, third, second, first. In closing, what I want to talk about is that the proponents of the bill are saying that we shouldn't charge children as adults, and we don't. See, 99.99% of the time, we don't charge children as adults, and a great amount of the time in Baltimore City, we don't charge them at all for anything. This is not for that. This is for 900 cases. My number was 600, but 900 cases over the course of a decade. This is not a large amount of people, but think of all the crime that's happened in those 10 years. So much so that there had to be a bicameral report on it back in 2017. And since that time, thank you,
wrap it up.
Things have only gotten worse. I urge an unfavorable for this bill, and to quit paying attention to this bunk. We need to address crime. It's a very small amount of people. Let's handle those people. Thank you so much.
Delegate McComas for questions, then delegates Crutchfield, Shoemaker, Conaway. Delegate McComas.
Thank you. This is for the folks that are unfavorable. My concern is that historically, the crime with juveniles has changed over the years. Is that a correct assessment? That in other words, it's become more violent and more concerning for juveniles, just generally. Well,
I think that's a difficult.
Say this: we have gangs. Okay, gangs recruit the kids. Gangs, for gang initiation, you have to become very violent. You know, it's not you get a tattoo. It's that you take part in a murder. It's you become violent. You steal. I mean, it's not good. And it escalates to more serious things. Is that fair to say? Well, okay, all right. That's what I can see silence. Okay. What I'm concerned about is that the judges, if a kid is charged as an adult, he goes before a judge. The judge sees a lot of criminal offenses by adults. So aren't they in a good position to kind of weigh the seriousness of what that child is charged with, because they deal with murderers, they deal with rapists, they deal with abusers. In other words, they see adults, and when they're looking at this kid, they kind of can see, well, this is really serious. Maybe it does need to go to adult court, as opposed to if you just start with the juvenile court, where there's not that ability to look at the differences. Is that fair to say?
Well, Delegate McComas, what I was going to say too is when the judges get involved, we're kind of already down the road in terms of the process of the charges. One of the concerns that I have, and I know some of the other people who have testified unfavorably, is how the process starts. in terms of whether a juvenile is initially charged as an adult or charged as a juvenile. The process is very different. And in terms of the safety of the community, it's easier to detain someone charged as an adult. It's a quicker process than if they're initially charged as a juvenile. So when we get to the process where the judge reviews whether it's a transfer or waiver to determine if a juvenile should remain an adult or return to the juvenile system, certainly judges are qualified. They get a lot of information. But one of my main concerns is how the charges start and in terms of how that protects the community. And I think when you have serious violent offenses and you have juveniles who, based upon their age, qualify as adults, that they should start as adults for the protection of the community.
Okay, well, thank you very much, gentlemen.
Delegate Crutchfield, please.
Thank you very much, Mr. Chair. This is for Mr. Passionik.
Patashnik.
Thank you very much. Listen, I just want to understand, are you saying that we should have sympathy for you because it's difficult for you to do your job because the burden has shifted to you to prove the factors in the Davis case while petitioning the court for waivers? Is that what you're saying here?
No, Delegate, I'm not. And I apologize if you got that impression from my testimony. First of all, I do want to thank you for bringing in an important issue for all of us to discuss. Where I take issue with this bill is one of balance. And what the advocates are saying with respect to this bill is that there still is a way for the state to just waive a child if they believe that child should belong in the adult system and a judge can just decide. But it's not that simple. The burden switching and the standard hamstrings the state from the beginning so that we don't get a fair shot at attempting to try to prove what we need to prove, because the way that it's set up leads us to believe, and I think that the law would bear it out, that for the most part, those violent individuals who should be in the adult system will likely end up in the juvenile system because the system itself, the process itself, is not even from both sides. I'm asking for a fair shot. If that means that we adjust the standards and the burdens so we get that fair shot, so be it. But that's not the law right now. And as this bill sits right now, we would be at an incredible disadvantage. That's what I was advocating.
Mr. Chair, just one more question. I guess I want to make sure I understand, because I thought the Davis court, that case provided that the same factors are used for transfers as well as for waivers. So I guess I'm a little confused in the fact that, yes, obviously now, with this legislation, the burden would be on you to now prove it and move it up. But, I just don't understand and see where you're going with this. And that's really it. I just don't understand that, because I don't see that you're adding or you're suggesting anything further than saying that now you got the burden and you don't want to prove it. No. You believe that it's just so much more or so much greater than what the defense would have to prove if it's a transfer. So that's where I'm coming from on this.
Delegate Crutchfield, that's not what I'm saying. The standard in a transfer is by a preponderance of the evidence, whether or not it's in the best interest of the child or society for that youth to be transferred from adult to juvenile. In a waiver, the standard is whether or not the child is unfit a subject for rehabilitative measures. Typically, before the Davis case, we had 5 factors that a court could weigh evenly or equally, or however the court wished to do it: age, mental and physical condition, amenability to treatment, the nature of the offenses, and public safety. All of these were considered in that standard, right? The Davis case blew that up. What the Davis case said was that all of the factors really should be subsumed into just amenability, nothing else. Everything was subsumed into amenability. And they redid the standard with respect to amenability and applied it to transfers and said, this is now the standard that all of you kind of have to follow. Yeah, a court can consider these other ones, but really the factor that they have to consider is one of amenability. which in a transfer case is great because it just made it easier for the defense to argue several different things. And it kind of standardized what that was. It balanced the playing field. But if you don't have transfers, if you just have waivers, then unfortunately, the dynamic that you have is that with that new standard, along with the standard that's in statute, the child is an unfit for rehabilitative measures, doubly makes it assured that if a defense says in rebuttal to the state's presentation, oh, by the way, there is some sort of service this child could have, then we lose. Add to that that the Department of Juvenile Services does now a new transfer waiver report where they have an independent or they have an assessment done by a psychiatrist for that child. If I, the state, challenge that assessment, I can't have that child independently assessed. I can't have that child sit down with my psychiatrist to go over what they said to the other psychiatrist. I can't do that. So because the child has a Fifth Amendment right against self-incrimination. And technically, I would argue that if the child refused to cooperate with the state in their assessments of this particular child, then there's nothing I could use that against him when I assess amenability. So we are hamstrung from the start. In a transfer hearing, the child has an incentive to handle with their public defender. The child has an incentive to cooperate. The child has access to their public defender and to their defense counsel. We don't have that access. So not only is the standard against us, not only does the Davis case double down on that standard, but we also don't have a chance to rebut. Those are my problems.
Okay. Delegate Shoemaker, then Conaway, then Cox.
Thank you, Mr. Chairman. I see there are a couple of my friends from Carroll County that are on this panel. I want to pose this question to Ned Coyne, if I could. Ned, you still there?
Yes, thank you.
Okay. It sounds like the proponents of this bill want to be able to rely heavily on the services of DJS. I mean, that's what I glean from it. I mean, can you speak to what you've seen in our county and I guess across the state with regard to the funding challenges and the staffing issues that DJS has experienced, and offer an opinion as to whether they're able to undertake this responsibility that would be foisted upon them?
Yes, thank you for the question, Delegate. Yes, so I've been working with juvenile since 2000 in Carroll County since 2001. And when I first started, we had 10 juvenile probation workers in 2001. Every high school had a juvenile probation worker. That way the kids didn't have to miss school. They just went down the hall to see their probation worker. We're down to 2. So we went from 10 to 2, and crime hasn't gone down that disproportionate to I guess, merit that reduction. And I would say, in Mr. Potashnik's memo, I think he reflected when you adjust for inflation, I think the budget shrunk by $86 million. Because as I think Mr. Culver said, when they close these facilities, they don't reopen new ones. So the money just goes away. And so that's the biggest problem, is that this bill places a great amount of confidence and relies a lot about DJS. But I would suggest, based on recent times, all you have to do is look at the newspaper about juvenile crime and facilities, that a lot they're community-based programs that are not affiliated with the government that can be accessed by both the adult system and juvenile system. It's not DJS is the one that's pushing that. And the biggest problem I have is DJS. There's a lot of barriers for DJS to detain people based on policy. And so simply saying, well, DJS is going to detain them right away. No, that's not the case. If you read Mr. Potashnik's memo, getting an arrest warrant and detention is very bureaucratic. Unlike the adult, if a policeman sees an adult crime, a murder, he makes the arrest and the public safe. The person can have a bail read the next day. And again, there's some myths on the other side of the proponents. An adult judge can place a juvenile charged with an adult offense in a juvenile facility the next day at the bail review. Under the transfer statute, it permits a adult judge to put a juvenile charged with adult offense in a juvenile facility pending the outcome of a transfer hearing or pending trial. So again, there aren't a bunch of juveniles sitting at detention facilities. if they're charged with adult offenses, for the most part, they're in juvenile facilities pending the transfer hearing or the trial. So again, DJS has been given a lot of confidence with this bill, and I would suggest their performance over the last 20 years doesn't necessarily merit that confidence.
Thank you, Ned.
Delegate Conaway, then Cox.
Thank you, Mr. Chairman. Thank you, panel, for coming in and testifying. So to the gentleman that was just speaking, what is the potential difference in time between a transfer and a waiver from the time a juvenile is arrested?
So there were some studies from the Juvenile Justice Reform Council that there were some time discrepancies. However, in light of Davis, I think Mr. Potashnik testified this on the Senate side for the cross-filed bill, that in the past, transfer took longer because the defense attorneys, usually the public defender, would hire their own experts, social workers, psychologists, to evaluate their client, which would extend the process of transfer from arrest to a transfer hearing. In the waiver side, the Department of Juvenile Justice prepares the waiver hearing. Defense doesn't hire its own experts, so it appeared to be a little shorter. However, though, I would suggest that with the new Davis standard and everything else, these timelines would be the same. So again, the reasons for delay were usually on the defense side for the transfer. In some of the studies that said it took longer because the defense had to get their own experts. Either way, for justice, we want great evaluations for a judge. Again, a judge is deciding under the current format, notwithstanding some of the testimony on the other side, that a judge does decide where these cases wind up. The juvenile's behavior, especially with these vicious, violent offenses, decide where it starts.
Okay, I appreciate that testimony, but I have to tell you, you just told me nothing, because I need to know, are you talking about a day for a waiver, maybe a week for a waiver, a day for a transfer?
It takes weeks.
How much time we're talking about?
Evaluations and reports, because the Department of Juvenile Justice or the psychologists or experts have to write reports. So it takes weeks and sometimes months.
So the transfer might be overnight or next day.
No, both processes take weeks or months. And under both processes, people have to issue written reports. That way a judge and the attorneys know ahead of time what these witnesses are going to say, and on the defense side or state side, whether or not they need to supplement those witnesses. So it does take weeks or months because people have to meet with the juvenile, evaluate the case, type a report, send the report out, and then it might require other actions by the either side. So
right,
usually,
so just to be clear, you're saying in either case, the transfer or the waiver, it would take months, an equal amount of time.
I would suggest yes. Mr. Potashnik might.
So what would be the problem of charging someone as a juvenile and then a judge looking at it and saying, no, this person needs to be waived up to adult?
Because you're not going to get them in custody. So they're going to be out on the street a lot longer and potentially creating more victims. And in the process, as Mr. Potashnik just said, it's not an even playing field. You're not.
Okay, thank you very much.
Thank you for the question.
Delegate Cox.
Thank you, Mr. Chair, and thank you, panelists. Mr. Coyne, real quickly, two quick questions. First of all, I noticed in the fiscal note that the estimate from Frederick County, my district, is a little more than $250,000 annually for things such as expert witnesses, juvenile amenability, brain development, rehabilitative options.
I'm sorry, Delegate Cox. Delegate Conaway was unmuted there for a second. Go ahead. I beg your pardon.
It's okay. I thought I heard something there. Thank you, Mr. Chair. So, Mr. Coyne, in light of the Frederick County assessment, I noticed the bill does not provide an assessment generally across all 24 jurisdictions. Is that, in your view there in Carroll County, you think that's a fair and reasonable assessment for needing the additional prosecutor and investigator, that $270,000 annually?
I don't know about the numbers, but I do know it's going to require a lot more work if this were to wholesale all vicious, violent offenses going back to juvenile. As Mr. Potashnik said, the hurdle is going to be so immense that to get justice for our victims and to keep the public safe, we would have to explore all these experts and potentially have additional prosecutors, because it's going to require a lot more work, because the factors on top of the case law from Davis require us to try to get as much information as we can to again, send these vicious violent offenses like murder, rape, carjacking, people using guns for crimes of violence to the adult court. It would certainly, we'd need a lot more resources than we currently have to be successful and hold violent people accountable and make sure the public's safe.
And I noticed that although the judiciary didn't have a response, significant response, Frederick County advises additional judicial resources for the circuit courts as well. So I'm thinking, I mean, if you take that number, it's close to 6.5 million annually that's not stated presently in the fiscal note. That would be additional burdens on the counties, it seems. And then the follow-up to that question would be, do you think that this would bind the judiciary and the prosecutorial discretion when it comes to violent offenders? And I think you've spoken to that eloquently. I just wanted to hear it in the context of what happened in Frederick County a couple of years back, where some juveniles that killed a man at the Frederick Fairgrounds. And, you know, because of judicial and prosecutorial discretion, they were able to decide after procedures to put those those two young people into the juvenile system. But, you know, that was with a weight of the evidence. It gave them that discretion. Do you think this takes that away?
It does to some degree. I would suggest that we take every case individually. Unlike some like DJS, we do review every case individually that's charged both juvenile and adult. We take our jobs very seriously and make sure that we want justice to prevail. So I just know that this is not a balanced act. It doesn't represent public safety and rehabilitation. It only solely focuses on rehabilitation of an offender committing, in many cases, in at least 18% of the cases, violent, heinous acts that, again, adult behavior, especially when you use a firearm, should start in the adult court. And then a judge individually can look at every case individually, like they did in Frederick County, and look if there's any trauma of the child or any adverse circumstances, upbringing, decide, you know what, instead of adult court, let's send this case back. We usually do try to look at every case and get justice on the individual circumstances. So in a transfer hearing where we think, you know, this guy deserves to be transferred, we get the victim's input, and then sometimes we do agree, sometimes we don't, and we have an adverse hearing. Again, someone who in cold blood shoots someone and kills someone, oftentimes is going to be an adverse or adversarial hearing where the state's going to advocate for public safety and the defense might advocate for mercy or transfer back to juvenile court for rehabilitation only.
And thank you, Mr. Chair. One more quick question for any of the panelists. So I also noticed that the education articles repealed. And as you know, in our committee, we have been concerned about the fact that when students commit a violent act or like rape and then are not, the notification process is prevented as they transfer to a new school. It happened it has happened where that person has then raped another student because the principal of the new school was not informed, was not allowed to be informed. This takes away the information of that student's school itself. So now we're completely putting everyone in the dark. Is that anyone on the panel can speak to that in terms of the change to the education article?
I just know that, Delegate, I know that there are reportable offenses even for those committed by juveniles, but off the top of my head, I don't remember the list off the top of my head, but I do know that there are reportable offenses even committed in the juvenile system where the law enforcement are required to notify the school system.
Well, it says here, and thank you, it says here that those would include gang charges, violent crimes, weapons charges, drug theft, intimidation-related charges, malicious destruction of property, second-degree assault, and auto theft. And those are all being repealed under this bill, so the principal will never know. No one will know.
Okay.
Is that your understanding too, in terms of the change?
I was not aware of the recent change, but I was aware in the past they have like distribution of CDS, sex offenses, violent offenses. I was familiar in the past, they were required to notify the local school system.
Thanks so much, gentlemen.
Delegate Davis.
Thank you, Mr. Chair. To anyone who would like to answer, I'm assuming that you saw the testimony from the proponents of this bill. And I am always amazed by the fact that you seem to poo-poo the fact that we're disproportionately traumatizing young Black males, and you offer no solution, you offer no sympathy, no empathy. You just want to lock up people as much as they can. And there is a question coming. What do you say to the disproportionate effect that is happening on certain parts of our community? And what is the answer?
Well, Delegate, we certainly have sympathy, and no one's poo-pooing anything. Our concern is we're saying it shouldn't be all adult crimes should not be able to be charged as a juvenile. We're saying it should be looked at closer, that the safety of the community is certainly a consideration. So we heard the testimony of the proponents, the personal stories. Those are difficult to hear. I certainly agree with that. And certainly there are options, but what we're saying is this will have a ripple effect across the adult and the juvenile system. And as I indicated, maybe this can be tabled for further discussions. I'm not saying, hey, we can't do anything. I'm saying this just needs to be looked at in more detail to figure out a solution where we can take into consideration rehabilitation of juveniles, but also victims' rights and the safety of the community.
Mr. Chair, I don't have an answer yet, but I want to restate that as high as 80% of these youth that have been accused, just accused, are coming back into our communities or never charged as adults or never even criminally charged as adults. And you still make the same argument and you see nothing wrong with the fact that as high as 90% of them are African Americans.
I can say that in Carroll County, we don't have that high a number in terms of juveniles that are charged as adults that don't go forward as adults. I can only speak from my experience.
Are there further questions for this panel? Seeing none, that concludes the testimony from those in opposition to House Bill 294, and it concludes the testimony on House Bill 294. Now, last bill of the day, we have House Bill 459. It's my bill. Committee, you will remember that, where did I put my notes? Helps to have your notes handy when you're about to do your bill, but sometimes there they are. Last year, we had legislation in the House that passed the House that addressed the first set of recommendations from the Juvenile Justice Reform Council, recommendations that were broadly supported from both sides, and I think it left the House with a significant support. We're here again today to move those recommendations again because they did not pass the Senate before sine die. The bill last year included there was funding in that legislation for the ROCA organization, but there were, other than continuing the work of the JJRC, it did not actually pass the policy recommendations. So this legislation, again, is the policy recommendations, and it also establishes a Juvenile Justice Reform and Emerging and Best Practices Commission to be charged with looking at the best practices for promoting child welfare, improving juvenile rehabilitation, supporting mental health services for children, and evaluating prevention and intervention services for juveniles. When we initially pushed, and I initially pushed forward the Juvenile Justice Reform package, my hope was that in a second year, we would be addressing more of the services that were available after addressing some of the policy issues that needed to be addressed. Unfortunately, we didn't get that far, so that's why we're here with this legislation again. So I'd like to introduce my panel and have them provide their testimony. Dylan knows that there is a PowerPoint presentation involved. So we'll hear from the Secretary of Juvenile Services, Secretary of the Department of Juvenile Services, Sam Abed, and the Deputy Secretary, Betsy Tolentino, who will speak to the legislation. Mr. Secretary, we're going to give them a grand total of 4 minutes between the two of them. Let's just do that. All right, 4 minutes.
Thank you, Mr. Chairman and Vice Chair Moon, members of the committee. Thank you, Sam Abbott, Secretary for the Department of Juvenile Services. I'm going to go very quickly. If we could move to the next slide. This is the timeline. I believe Chairman Clippinger already covered that, so we're going to go ahead and move to the next slide. This is the membership. The big point here is that we had a very diverse group, and we had, very diverse group. That's the big point. Next slide. This is the voting on the recommendations that appear in the bill before you today. And this is important to look at because we did have such a diverse group. We had legislators and practitioners and child serving agencies, experts, voices from the victim community, law enforcement, national experts as well. And you can see there was largely consensus on the bills. The last vote there is on the bill that you heard earlier, House Bill 294. The others on this list to the left of that are the ones that are in this bill. Next slide. One more slide after that. So I want to cover very quickly the trends in our system. And you can see we start with complaints because complaints is the universe of our system. This is what sets everything that comes after that. And it is a count of how many charges were brought against young people. So this is very much a look at the offending patterns for young people in our state. And this is statewide data. And you can see over 10 years, it's declined by 78%. So in fiscal year 12, we had 33,000 complaints brought against. These are charges of criminal offenses brought against youth. 33,000 in fiscal year 12. We had 7,000, just over 7,000 in fiscal 21. And one other thing that's important to note is as we go through those 10 years, it is a steady decline. Each year it declined for those 10 years. So if I move just to fiscal 20 instead of fiscal 21, you would still see an over 50% decline from fiscal 12. So every single year it's gone down. And of course, if you look at the next part of this slide, you can see in all categories, crimes of violence, misdemeanors, and nonviolent felonies, all categories have declined significantly. Now, there was some conversation about carjackings, and I will acknowledge when I look at the data, even though crimes of violence as a total are down significantly, not just over the 10 years, but year over year, they're down significantly, carjackings are up. So that is something that we need to look at, but that is something that very much bucks the trend of all of the other criminal offenses, all the other categories, and other crimes of violence. You can see that detention numbers have declined over the years, and if we could move to the next slide, we'll see that those dispositions, and this is important to note, probation dispositions declined by almost 84%. 84%. So when we talk about the number of probation staff that we have to look at, well, what is their workload? We had 4,400 probation dispositions in fiscal 12. In fiscal 21, we had 720. It is a enormous decline. And you see that follow in the committed population down 85%. And of course, our out-of-state average daily population is also significantly down by over 90%. And so that gets me to the budget. And it's important to look at that budget because while it has decreased significantly over the years, it is decreased because our numbers are down, not because we have decreased resources to kids. The resources that are going to kids have moved from residential services to community services. So you can see that we spent $56 million on residential services in fiscal 12 and only $9 million in 21. That's because we're incarcerating fewer kids. But you see that the number of community service dollars went down very slightly in comparison, even though their decline of probation dispositions was just as significant. And that's because we are spending our money in the community upfront to try to get better results with our kids, resulting in lower recidivism, as you can see. And with that, I would just add that I support this legislation and urge favorable report. Thank you, Mr. Chairman.
I think the secretary ate up all of Betsy's time too. So maybe somebody will have a Betsy question here, but who knows? Why don't we, we're going to take questions from the panel because we need to do that. I was giving you both time this as a group. Are there questions for the Secretary of the Department? There we go. Delegate McComas.
Good grief. I'm like, this is like the alternate universe. I mean, you know, because you watch television and you think, oh my God, it's juveniles run wild in Maryland. And so what are you guys doing that things seem to be going well? What programs, in other words, what magic dust are you spreading around to lower those numbers? Because I'm impressed.
Well, thank you, Delegate McComas. And I wish there was magic dust, and I would, if there was, I'd share it with everybody. But if I could bring it back to the whole country, the trends that we're seeing here in Maryland in those complaints going down significantly, that's a trend we see everywhere. So I do think that there is differences in the way kids behave now. And I think if you think about how our society has changed, 20 or 30 years ago, there wasn't ubiquitous access to the internet. Kids now spend a lot more time online than they used to, and that means that they're not in person with each other. Of course, over the last 2 years with COVID, schools have been closed for large periods of time or on virtual learning. And so again, the opportunities for things to happen are diminished when we have social separation. But I do think that over those 10 years, we have seen changes in youth behavior. And of course, it's not just the larger trends that are happening across the country. We've also been implementing reforms here in Maryland over the last 10 years. And as I mentioned in my comments, we have changed. Instead, we used to spend twice as much money incarcerating kids 10 years ago as we spent in the community. Now we spend 3 times as much money in the community as we spend incarcerating kids. And the reason that we're spending so much in the community is that we have opened up all of the services that you used to have to be adjudicated delinquent for. We opened up all of those up at intake so that we can give kids services where they need them to get things without. I'm sorry.
No, it was Delegate Conaway again. I'm sorry.
Okay.
Who accidentally unmuted himself. It's all right.
I'll go ahead and conclude my response there.
Fine. All right. Thank you very much. Assistant Secretary, do you have anything you want to say in answer to that question?
No, I don't have anything to add at this point. Thanks.
Great. Let's hear from Delegate Crutchfield then for a moment. Delegate Crutchfield, for your questions.
Yes, thank you, Mr. Chair. So we just had a bill hearing on HB 294, which deals with repealing direct charge of children. And so one of the things we repeatedly heard from some of the, well, I'll say all of them actually, the state's attorneys represented was that DJS just doesn't have the services. DJS just not ready for children to be brought in and to be actually under their jurisdiction. What do you have to say about that, Secretary and Assistant Secretary?
Thank you, Delegate Crutchfield, and I appreciate the question, and I'd say that we are ready. I think that the data that I just presented really shows that we have the capacity, we're ready to implement these recommendations. We have seen over the years that the reform efforts that we have implemented in the past are bearing fruit because we're having fewer kids commit crimes in the first place. So it's not just reduced recidivism, which is important. We obviously want to be working with the kids that we have, that come into us and eliminate their threat to the community or mitigate that. But the fact that fewer kids generally just are not committing crimes. When you look at the number of complaints, 33,000 down to 7,000 is just an extraordinary decline. And I think that what I would say is that in terms of our budget, we've always had everything that we've ever needed. The reason that we have a lower budget is because we incarcerate less. I spend everything that I need. I don't want to say that I overspend, because I don't. But I've never needed money for something that I couldn't find in our budget. And in fact, we end up usually reverting back millions of dollars, because those declines in incarceration, it costs a lot to incarcerate children. So when we reduce that, the state benefits tremendously, not just because we're not harming those kids, but also because we're saving dollars.
I will also add, this is Deputy Secretary Betsy Tolentino, that we have built out a continuum of services that are designed to meet our young people's diverse needs. We have hundreds of programs around the state that deal with substance use, behavioral health, violence prevention, peer counseling, mentoring. We also have a continuum of evidence-based programs, meaning programs that research has said work, that reduce the likelihood of recidivism. Last year, we had 492 kids placed in a evidence-based program. On any given day during fiscal year 21, 192 young people in the state of Maryland were in an evidence-based program, and we're bringing more on. We have an RFP right now to bring in additional evidence-based programs to be able to make sure we have the right programs to intervene and support our young people and promote safety in our community.
Are there further questions for the Secretary, Deputy, and the Deputy Secretary? Seeing none, thank you all very much. We'll go now to the other witnesses. We'll give them 2 minutes. How about that? Marlon Tillman, Josh Rovner, Mikhail Gross, Jenny Egan, and Scott Schellenberger. We'll have them come up next. And if we could have Dr. Tillman begin, please, for 2 minutes, that'd be fine. Dr. Tillman?
Yes, sir. Always got to find that mute button. Thank you, Chair, Vice Chair, Honorable House Judiciary Committee. I'm speaking on behalf of Bridge, Maryland, in support of House Bill 459. We thank this committee for passing this legislation out of committee in 2021. So my comments will be brief and only addressing raising the minimum age of juvenile justice jurisdiction to 13 years old. I have 2 granddaughters, 6 and 13 years old. Both are bright, straight-A students living in good homes. They live in Baltimore City and Howard County, respectively. And it is frightening to believe that either of them could have a bad day, make a bad decision, or be in the vicinity of bad behavior under current Maryland law and be detained, arrested, or incarcerated like an adult, with no consideration of their immaturity, age, or the trauma they could experience by that experience. We can do better than this. Thus, Bridge, Maryland, with the membership of over 7 faith traditions, feel it is our moral imperative to protect and reduce the risk of emotional, cultural, and situational trauma that could impact children and youth into their adulthood. We urge this committee, again, to issue a favorable report on the Juvenile Justice Reform Act, House Bill 459. Thank you for my time.
Josh Rovner, please.
Thank you. My name is Josh Rovner. I'm a resident of District 18 and Senior Advocacy Associate at the Sentencing Project. It's unfortunate that we find ourselves here again, waiting for the passage of the widely supported reforms recommended by the JJRC. We strongly support HB 459 and certainly thank this committee and the House of Delegates for having passed it last year. I'll focus on the bill's language on limiting detention and commitment. Youth charged with misdemeanors comprise about 40% of youth in detention and about 50% of the youth committed to state-operated facilities. As with all points of contact with the juvenile justice system, Black youth are disproportionately detained and committed. Now, given the importance of peer interactions, incarcerating youth who are at low risk of reoffending or have been charged with low-level offenses in detention is a pathway toward more serious offending. Moreover, limiting detention and commitment for low-level offenses is another step toward closing more facilities and redirecting the subsequent savings toward better uses. So thank you for your time. Thank you for all your work on this, and I hope we'll pass it again this year.
Michael Gross. Michael Gross? I'm mispronouncing the first name. All right, we'll move forward here. Jenny Egan.
Thank you, Chair. Thank you so much for bringing this important bill. The JJRC made these recommendations after studying the scientific literature, consulting local and national experts, and taking a hard look at data that had not previously existed or been provided. These recommendations are data-driven solutions required to keep people safe and reduce recidivism amongst young people. It does four things. It bans incarceration for low levels offenders. It raises the minimum age of juvenile jurisdiction because we know most children under the age of 13 are not legally competent to stand trial. And it caps juvenile probation that's tiered according to the seriousness of the offense. I'm happy to answer questions about any of those measures or what the JJRC found. But I want to talk about probation. Right now, all juvenile probation is indefinite. Probation that is focused on technical compliance rather than tangible, holistic goals places young people at risk of being violated, detained, or committed for non-criminal behavior. I have clients right now who get kept on probation for the inability to pay restitution, for their failure to attend school, for disobeying their parents, for staying out too late, for sneaking their significant other into a basement. In other words, for being a teenager. Probation being extended for reasons not related to new offenses deepens young folks' involvement in the criminal justice system and deepens existing racial inequities that exist inside of that system. Our opponents will say that caps on probation mean the courts will be prevented from helping kids. Remember that the evidence all shows across the board that extended court involvement can make delinquency outcomes worse if a child is not reoffending. After a period of probation supervision, if a kid has not reoffended, we should not let it drag on and on. If we want young people to view the system as fair, as equitable, as helpful, if we want it to be developmentally appropriate so a young person can understand, then when they complete a set term of probation without incurring new offenses, they should be rewarded with an end to their supervision. Happy to answer questions, and thank you so much, Chairman.
Thank you. All right, Ms. Gross is here, so we'll take Ms. Gross now for 2 minutes, please.
Thank you, Mr. Chair. I was stuck in the waiting room when I was called before. Mr. Chair, Mr. Vice Chair, and members of the committee, my name is Michal Gross, and I am an assistant public defender representing youth in Southern Maryland. I'm testifying today in support of JJRC's recommendations, but specifically focusing my testimony on the recommendation to raise the floor for juvenile court jurisdiction. Too often as youth defenders, we are representing kids who are being prosecuted for acting like kids. This is especially true when we represent preteens. They aren't being arrested for serious charges. About half of the arrests for children under 13 are property offenses, and a full quarter are misdemeanor assaults. And even those are just kids being prosecuted for behaving like kids. Those misdemeanor assaults, those are middle school boys squirting juice at girls that they like. That malicious destruction of property, that's a fifth grader who broke a window playing baseball, or an 11-year-old who colored on her friend's jacket. The theft charges, that's a kid who took a bag of chips that had been left in the cafeteria, and a 9-year-old who rode a bike someone left in his yard. Children under 13 can't really understand court. They don't understand what their rights are. When they think of right, they think of it as in right and left, or right and wrong, not an affirmative right to remain silent. And they don't understand the adversarial process, why someone who is their friend might still be a witness against them. And they can't think through the long-term consequences required for a court. Try explaining to a 10-year-old that they can be held at an out-of-home placement until they turn 21. That's more years than they've actually been alive. More than half of these charges are resolved without ever making it to court. So why are we putting children through this trauma? Why are we allowing a 10-year-old to be placed in the back of a police car in handcuffs with lights and sirens to be interrogated at a police station for allegations of kicking a car, all the while he's crying that he wants to go home? I'll end my testimony with the story of Kay, an 11-year-old client of mine who was charged after an incident with her neighbors. Kay was forced to endure the juvenile court process. Throughout the year that Kate was coming to court, the families had actually resolved any issues. They had the kids apologize, they had the kids make amends, and the kids were playing together every single day. The families spent birthdays and Halloween together, but Kate still had to come to court, an ordeal that terrified her for a situation she could no longer remember before the case was finally dismissed. I'd ask that you prevent situations like Kate's from happening and don't allow any other child too young to understand what court is to be traumatized by these unnecessary arrests. And I'd urge the committee to issue a favorable report.
Thank you very much. We're going to hear Mr. Schellenberger is not here. We'll hear from Megan Berger, then Nick Maroney, then we'll take questions. Megan Berger, please, for 2 minutes.
Good afternoon. I'm an attorney with Disability Rights Maryland, the state's protection and advocacy agency. DRM supports House Bill 459 because it will improve youth justice outcomes and as a result will better serve youth with disabilities. Nationally, students with disabilities are overrepresented in the juvenile justice system by a percentage between 30 and 60%, with some estimates citing even higher percentages. The juvenile justice system has become the default system for youth with disabilities who don't receive the proper supports, including mental health care in the community. Our current juvenile justice model does not provide rehabilitation or prevent recidivism, and HB 459 aims to fix that. Youth incarceration exacerbates systemic patterns of disparate treatment and solves very little when compared to diversion programs tailored to the child, which provide youth with assistance they often need to thrive. HB 459 will promote a system of restorative justice by removing barriers to diversion and providing youth access to substance abuse rehabilitation, critical mental health treatment, mentoring programs, job training, mediation, and community service, and other restitution measures outside of incarceration and fines. This in turn will result in less recidivism by youth. The bill provides us an opportunity to course correct and transform the youth justice system into one that benefits more young people, families, and communities. Reforms that raise the minimum age for jurisdiction, place developmentally appropriate limitations on probation, remove barriers to diversion, and ban child incarceration for low-level offenses will ensure that as many children as possible are treated with community-based services that lead to better public safety outcomes at a fraction of the cost of deep end interventions. Thank you.
Thank you very much. Nick Maroney, please, for 2 minutes.
Good afternoon again, Chair, Vice Chair, members of the committee, Nick Maroney, Juvenile Justice Monitor. So what we found in watchdogging DJS over the past 20 years, we've gone from a system where there was rampant systemic abuse to us and very few effective services for kids to a situation which is not just marginally improved, but hugely improved, despite some of the comments made earlier. We oversee them in an objective fashion. We visit the detention jail equivalent, the detention facilities. We visit the placement facilities, the prison equivalent. We do that unannounced. We advocate for better services for the kids. We move collaboratively with the department. And objectively, what we've seen is an absolutely huge improvement. Also, kids who are charged with so-called very violent crimes are not left in the community. If a kid is starting with the juvenile system, they'll be held in a maximum security detention facility. So these DJS is running secure facilities. They're not just letting folks with serious charges, even though they are just charges and unproven, they're not letting them run around in the community. So I think it's very important to dispel those kinds of misapprehensions. Over the past couple of decades, and especially in the last decade, DJS and the courts have both increased efforts to ensure that young people who don't pose a threat to the community are kept out of this deep end of the juvenile system. But there's only so much that they can do. Things are working better. That's why we're in the situation we're in. So let's not twist things around and pretend otherwise. But they can only do so much, the courts and DJS. They need things to be codified in order to ensure ongoing improvements in the juvenile justice system. The Reform Committee, of which the chair was a member, as we know, consisted of a very cross-section of folks. It included prosecutors and public defenders. It included legislators. It included victim advocates. It included formerly incarcerated youth, and etc. the recommendations that are in this bill coming from that committee were overwhelmingly supported by the majority of people on that commission, that council. So these are modest fixes. They'll help ameliorate some of the problems with the
Mr.
juvenile
Maroney.
justice. Yes, sir.
Yeah, I got to
I'll
wrap
finish
it.
it up. They will help ameliorate some of the problems still associated with the juvenile justice system in our state. Things like open-ended probation periods, things like a permissive approach to incarceration that still allows for very young children to be detained in maximum security facilities. These kinds of issues have to be addressed if we're going to have continue to head towards a more effective juvenile justice system.
All right.
So for all of these reasons, the Juvenile Justice Monitoring Unit, the independent monitor, fully supports this bill and respectfully urges the committee to do the same and to give it a favorable report.
Has anybody got any questions for this panel? Seeing none. Thank you all very much for your testimony today.
Thank you, Mr.
Thank you. We'll hear from another panel. And I'm going to give a person the option to testify if he wants to or not in this panel. Darrell Frazier, Mark Schindler, James Dold, Melissa Goman, Garrett O'Day. Gavin Potashnik from the State's Attorneys Association is here with an informational testimony. He can testify or not. We'll find out when we get to that part of this panel. Let's go ahead with Darrell Frazier, though, for 2 minutes, please.
Yes, sir. Once again, thank you, Mr. Chair, Vice Chair, and members of the Judiciary Committee for allowing me to testify in support of House Bill 459. House Bill 459 implements a range of reforms aimed at diverting young Marylanders from the youth justice system. Once again, I'm representing the Mental Health Association of Maryland as their Policy and Community Engagement Manager. I'll be speaking from more so of a mental health, behavioral health perspective, as a lot of my peers have already highlighted a lot of the information that is very important and critical to this legislation. Mental health disorders are prevalent among children in the juvenile justice system. A recent meta-analysis suggested that at some juvenile justice contact points, as many as 70% of youth have a diagnosable mental illness. While there appears to be a prevalence of unmet mental health needs in the juvenile justice system, the relationship between mental health and the system's involvement is complicated. Youth involved in the juvenile justice system frequently exhibit elevated rates of substance use and mental health disorders. Many of the studies examining this issue have found that over 2/3 of juvenile justice involved youth have a mental health diagnosis or need. Over 20% have a mental health disorder that could be diagnosed as severe. Common diagnoses include behavior disorder, conduct disorder, oppositional defiant disorders, antisocial behaviors, mood disorders, substance use disorders, anxiety, and the list goes on and on and on. While the rate at which mental health and behavioral health resources are used in juvenile justice settings is low in general, it is even more deficient for African American and minority youth. For those reasons, the Mental Health Association supports HB 459 and urges a favorable report. You can also refer to my written testimony for additional data and analysis. Thank you.
Mark Schindler, please, for 2 minutes.
Good afternoon, Chairman. Thank you for having me. My name is Mark Schindler. I serve as Executive Director of the Justice Policy Institute, a national research and policy organization. Over the last decade, we've issued over a dozen policy and research reports on the Maryland justice system. I've submitted written testimony, so I won't go into too much detail, particularly in light of the time of the day and how long you've all been at it. I come at this issue from a number of different perspectives. For the purposes of my comments today, I'm speaking as the former head of DC's Juvenile Justice Agency, the Department of Youth Rehabilitation Services, where I served 2005, 2010, a number of leadership roles. I want to start by thanking you, Mr. Chairman, and the committee for legislating and creating the JJRC and for the work that they did. I commend my former counterpart, Secretary Abed. I think his presentation and the recommendations that were made are exactly the type of approach to policymaking that Maryland should be pursuing consistently. The recommendations being offered are research-based, and they'll allow Maryland to much more effectively, in my view, to right-size the system. That is to ensure that precious taxpayer dollars are focused on the youth who most need those resources and attention to get them on the right track, and not spending considerable time and resources on youth who can best be served outside the system. So I think the recommendations are very sound. And I would just say there's been real progress in Maryland over recent years, but there's still a lot of room for improvement. And we know from the research we and others have done the disparate impact on youth of color. What we're talking about is mostly young Black boys who are being negatively impacted by the system and who are going into the adult system in dramatic numbers. The recommendations from the council, I think, will point us in the right direction and lay a good foundation to build on the success that it's already occurred. I'd be happy to answer questions. Particularly, I note the recommendations to limit probation, I think are probably amongst the strongest that the council made. And I'd be happy to speak to that as well. Thank you.
Thank you very much.
Urge support.
Thank you very much. Let me get that on. James Dold.
Good afternoon, Mr. Chairman. I'll try to keep my remarks brief. Just want to thank you again for introducing this important legislation. I want to speak specifically to Section 1 that deals with the establishment, the minimum age of 13, which can go down to 10. Again, this issue, and I hate to sound like a broken record, is a human rights issue. Article 40 of the UN Convention of the Rights of the Child requires that nation states establish a minimum age below which children are deemed incapable of transgressing the criminal law. And there's a very basic and important reason for that, which is that these children, very young children, second, third, fourth, fifth graders, simply do not have the capacity to form mens rea. That is, that they are not criminally competent to understand when they've done something wrong, let alone the legal processes by which they're being held accountable. I don't know if folks on the committee have first or second graders, but try asking them to explain what their Miranda rights means. And this is really important when we're considering how we hold young people to account and what we do specifically when they come into conflict with the law. It's a common sense measure. It's why the American Legislative Exchange Council, which is a conservative group, has recommended that states pass a minimum age of at least 10. It's why Texas, Louisiana, Mississippi, Arkansas, Utah, Nebraska have all passed similar legislation. And it's why we would also urge this committee's favorable report of this very important and significant legislation. And I couldn't end my testimony without also highlighting the fact that, again, when we get down to brass tacks, Mr. Chairman, the kids who come into the system are victims. They've experienced severe amounts of trauma, and that is what is leading kids into the system. And that is why we need solutions that are outside of the system that are focused on treatment and rehabilitation and services for the trauma that these children have experienced instead of a criminal justice reform response. And with that, Mr. Chairman, thank you for your leadership on this issue, and we're looking forward to this bill becoming law.
Melissa Goman, please, for 2 minutes.
Thank you, Mr. Chairman, members of the committee. My name is Melissa Goman. I'm with the National Juvenile Justice Network. I'm also going to be addressing the section of the bill that refers to raising the minimum age. And we urge you to pass this bill and to set a high minimum age for prosecuting young children in Maryland's juvenile courts. As you know, young children in Maryland are at great risk of trauma and the collateral consequences that are associated with arrest and prosecution, since Maryland currently has no statutory minimum age of prosecution. And I refer you to some of the disturbing racial data. In fiscal year 2021, 59.6% of Maryland's intake complaints were for Black children under the age of 13, even though Black children only comprise approximately 35% of Maryland's population. As James pointed out, this is an issue internationally. The United States is an outlier, frankly, throughout the world. In 2019, the UN recommended that nations set their minimum age at least 14 years old, and with no exceptions carved out to this minimum age. So at NJJN, we co-lead a national campaign to raise the minimum age of juvenile court jurisdiction throughout the country, and momentum has really been growing to do this. In the past few years alone, California, Delaware, Massachusetts, New York, and Utah have all raised their minimum age for prosecuting children in the juvenile system to 12 years old. And New Hampshire last year raised their age to 13 years old. And in this last year, 7 states passed bills raising the age of juvenile jurisdiction or confinement, and many more, such as Maryland, are working on it this year. So I thank you, Mr. Chairman, for introducing this bill, and I urge you all to pass HB 459. Thank you.
Thank you. Garrett O'Day, then we'll take questions.
Thank you, Mr. Chair, and members of the committee. And Mr. Chair, thank you especially for your involvement with the council, which the legislature has considered this bill over the last couple of years through a legislatively appointed council. I'm Garrett O'Day for the Maryland Catholic Conference here in support of this bill. We're also very much in support of the informal adjustment bill and the automatic end to the automatic charging of youth as adults heard earlier today. As a member of the Youth Justice Coalition, I'm charged with mentioning the coalition support for the bill. This coalition includes Maryland organizations such as MCC, the Office of Public Defender, or faith-based partners in Bridge, Maryland, and Strong Future Maryland, as well as the ACLU, and national experts such as the Sentencing Project, Human Rights for Kids, and R Street Institute. So speaking for the MCC, restorative justice measures are a priority from the perspective of church teaching. The circumstances that many system-involved youth face are generational, and there's a lot of things this legislative body has done to make our society better. Maryland needs to do what other red states have done, what other blue states have done, to ensure system-involved youth have opportunities to mend the root of their disadvantaged circumstances. So there's many great aspects to this bill, but the one that I want to point out is the restorative justice aspect, the expansion of diversion, much in line with Delegate Valentino Smith's bill earlier today. The creation of model policies to expand restorative justice and restorative sentencing, such as educational services, substance abuse treatment, mental health services, they all help address underlying adverse life circumstances so that those kids have a second chance and a much less likelihood of recidivism, so thus increasing public safety. Thank you very much.
All right, Gavin Potashnik has indicated that he will just refer the committee to his written comments that he submitted on the bill. So he is not going to testify orally. We'll take questions. Delegate McComas.
This is for Mr. Schindler. I was wondering, you said that the Black male youth seem to get the highest problems and I guess involved in the system. And I just wondered what were the factors that you feel lead them to be into the system, the juvenile system?
Yeah, I appreciate that question, Delegate. And what we've seen from our research is that young Black males in Maryland are disproportionately impacted by the system, going in at higher rates in the juvenile system and also in the adult system. We've also done research that looks at how Maryland invests in communities. We did a report in 2015 called The Right Investment that looked particularly at communities in Baltimore, but also around the state, that were sending the highest number of young people into both the juvenile and the adult system. And what we found is that those communities were particularly stressed on a number of well-being indicators, low employment levels, high substance abuse levels, and that the investment that we were making in those communities really emphasized as much or more using incarceration and law enforcement and suppression efforts more so than investments to build the strength of those communities. So I think this is a conversation that really bridges other parts of the government and the system. Back when we released that report, that helped, I think, lead to the Justice Reinvestment Act in Maryland on the adult criminal justice side. And I dare say that the recommendations coming out of the Reform Council really are a justice reinvestment type approach, looking to spend taxpayer dollars more effectively on the things that we know work. And that is investment in community. And for the very small number of kids who are exhibiting violent behavior, we should focus our resources on them. And if they need to be in a setting outside the community for some period of time, we should make sure that that is rehabilitative, that is intensive services. So I think the council's approach is consistent with what we see in the research, and hopefully would reduce the disparate impact on young people of color that we've seen for way too long in Maryland. So I hope that's helpful and responsive.
Mr. Dole also wanted to answer. Mr. Dole, go ahead, and then Delegate McComas. Mr. Dole.
Thank you so much, Mr. Chairman. Yeah, and I just wanted to highlight that there is some research and studies out there that also show that minority youth are disproportionately impacted by adverse childhood experiences and early childhood trauma, so that we see higher rates of trauma with kids of color. And again, going back to the point that, hurt people, right? So when you have kids who've experienced trauma and stress in their lives and it's never been resolved, that is a devastating circumstance for so many kids, and then they act out as a result of that harm and that hurt. Oftentimes when we have conversations about crime, I think there's this false dichotomy that we draw between victims and offenders. And what we see, particularly in the Black community, in the communities that we serve, is that there's an overlap. Right. And so it's really important to understand this fundamental dynamic, because of trauma and the higher rates of trauma in communities of color, those kids oftentimes, and that is also expansive, I will say, to also include racism, right? Racism is an adverse childhood experience. And so when you have youth of color who also experience that is going to increase, again, sort of those negative life outcomes, which include system involvement, poor health outcomes, everything that we've seen from the ACEs studies.
The follow-up is, are you aware of any, what you would say are good programs that work to try to solve some of these problems that are really kind of groundbreaking? So, because I mean, I think we need to know what really works with the problems that we're dealing with, within the Black youth.
Absolutely. I mean, I'll just echo the comments that Mr. Dole just made very eloquently. He's absolutely right on, right? And we actually just released another report just recently that looks at young people who are engaged in violent behavior. And as Mr. Dole indicated, those kids are almost exclusively had been victimized previously. And so we do have approaches that can address that trauma. And Secretary Abed had talked about the continuum that they are putting in place, and some of those exist. The report that we just released looked at 4 jurisdictions, and I would be happy to follow up with you on that, that are showing progress in there. That was Virginia, New York City, Washington, D.C., and Milwaukee, Wisconsin. There are also other places, and I think in Maryland as well, as mentioned earlier, ROCA, as a program that works very well in the community with kids who are involved in violent behavior, and knows that unless we address the trauma that young people are experiencing, then we're really not going to make substantial progress. And the last thing I would say on this, we also know that putting young people into a system based on an approach of corrections and law enforcement actually re-traumatizes them, right? And so if we're going to seek to address kids' needs, the first thing we need to do is do no harm, right? But when we put kids in handcuffs, in secure settings, that is going to re-traumatize young people and lead to worse outcomes. And so happy to follow up with you, Delegate. And I think you're asking exactly the right questions.
Thank you. I'd appreciate that, because I don't know what we should do. And so this will be the kind of the guide to figure out what we should be doing and what maybe we should.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. Mr. Schindler, thank you for your testimony. In reference to what we should do, and as far as African-American contact with law enforcement, would you say that law enforcement, generally speaking, has a greater amount of contact with African-American youth as far as charging and overcharging in situations?
Yeah, no, that's absolutely the case in communities in Maryland and across the country. Absolutely.
I understand it. So my question is, why is it that, I mean, I'm not trying to throw a blanket out, but it seems as though we're not understanding that there appears to be more contact with law enforcement with the African-American youth, and therefore more contact generally would lead to more small charges, which would generally lead to larger charges later on. Would you agree with that?
Absolutely.
Right.
No question.
So while we're looking at it as a trauma, this person might be traumatized, the African-American youth might get a citation for jaywalking or something like that, where another youth in another ethnic group might just get oral reprimand. Would you agree with that?
That's correct.
All right. Thank you so very much for your participation.
Delegate Cham.
Thank you, Chairman. So I'm hearing a lot of data and statistics about our African-American young boys and girls being disproportionately represented in these very egregious criminal acts, if you will. First question, what makes them disproportionately represented? Are they doing it more so than their white counterparts, boys and girls? What makes them stand out more in the data? Are they arrested more so than? Because certainly I'm sure white boys and girls also engage in these behaviors. Are they not arrested or charged as often as African-American boys and girls? Is that what makes, people who look like me, boys and girls, more represented in these data?
So it's a good question and complicated in some ways, in other ways not, right? And this goes to, what Delegate Conaway was talking about. I mean, some of this is just how we deploy resources, right? How police are deployed in certain neighborhoods more so than in others. I recall some years ago a conversation with a young person. This happened to be in DC, right? And DC had implemented a summertime curfew for young people because of some upticks in crime, right? And we were letting folks know, you got to be careful. And this young person happened to be a white upper middle class kid who lived in a white neighborhood. And he literally said, because the kids know, he literally said, that law doesn't apply to me. I don't have to worry about police in my neighborhood because they're not here. They're not looking for stuff when we do it, right? The young people actually know this. So they knew that curfew applied to young kids of color where police were surveilling in their neighborhoods. So that's one part of it. The other part, though, is we also know that we haven't invested appropriately in neighborhoods. So there are clearly neighborhoods and communities that do have high levels of violent crime, and that disproportionately is communities of color. And so we are creating environments where, yes, violence can thrive, where there is incredibly easy access to firearms. I think if we're having a conversation about this, we should have a conversation about the easy access of guns in our communities. Young kids of color are not bringing those guns into their neighborhoods, right? But those guns are getting there somehow and having lethal consequences. So there are a number of factors that will impact and influence why a disproportionate number of young people of color end up in the system and also are involved in violent behavior. But we have to, take a holistic view of that. And again, I do think that the council's recommendations are consistent with a holistic view that will at least push us in a direction of using resources more wisely and more effectively.
And if I may, Mr. Chairman, I think that both delegates sort of get at the key component of this, right, which is a combination of over and under policing. There's a really great book. I hate to throw out like a reading list, but it's called Locking Up Our Own by James Foreman Jr. Folks might have heard of it, but it highlights what Mr. Schindler is talking about when it comes to specific and targeted over policing tactics that target African-American communities instead of white communities. To the point, we know that for example, drug use, right, or engagement in drugs is consistent across all socioeconomic and racial categories. And yet we know that Black youth and young Black men in particular are disproportionately targeted as a result. So that's the over policing dynamic. But what we also see with victims of crime, right, there's an under policing element where those crimes aren't investigated to the same extent. They're not taken as seriously. And so what happens, you don't have the same sense of justice that comes up. So victims don't get services, they're not identified. And then that trauma, again, manifests itself and metastasizes over time. And then that is what leads to, again, these negative life outcomes as a result of adverse childhood experiences. So I think it is a very complex conversation, but it's the combination of both over and under policing in communities of color.
Ms. Goman, if you'd like to make a quick remark, that would be fine.
Yes, so I was just going to say, from our research, the self-reporting data really shows similar rates of offenses by white youth and youth of color. So I really think a lot of this is attributed to implicit and explicit biases. And there's studies showing, for example, that kids of color look older to white people, and so they have expectations for them that are different. You see over-policing by school resource officers in the schools, where again, children of color are arrested for things that white kids are not. So I think we really can't overlook this important part of what's showing up in the data.
Are there further questions for the panel? Seeing none, we thank you all very much. And we have one more witness who's testifying in opposition to the bill. It's Vince McAvoy. We'll hear from him for 2 minutes. And that will be it. Mr. McAvoy. Mr. McAvoy, 2 minutes, please.
All right, thank you so much, committee. I appreciate that. I want to start echoing something that Delegate Chan said about statistics, because as you looked at the very first thing that Secretary Abbott put out about the complaints declining over 10 years, and I have 2 comments on that. One, if you look back to Hogan's run back in 2015, they took polls saying that basically 47% of Marylanders wanted to leave the state. You look at recent polls in line with draconian COVID restrictions and so forth, Maryland is one of the #1 states in the country where people are exiting the state. That explains declines. Number 2, I can tell you, living in city, the reason that we are not seeing these charges is because police are telling us that they're not arresting. I know this from personal discussion with them. I know this also from anecdotal situations. So we're not arresting. That's why it seems like this focus on that we're hearing of crime and we're not seeing. It's because we're literally not arresting them. And there's a focus from the legislature and from other activist groups saying that we shouldn't. And this is misguided and the extremists. And that's why we have not seen any change in the amount of damage and people wanting to go, because of the disillusion with not paying attention to lifestyle issues. But there's another thing that's related specifically to the rule, to this bill, about how the age of criminals is getting lower. And that's because families are extremely fragile. Children and families are often neglected. As a result, this is a quote, a sense of hostility is developed in their minds, which eventually make them delinquents at a very younger age. This is what we're seeing. There's no stats with that, so I can't corroborate that. But that general tone is there. And so lowering the ages is exactly what we don't want to do. That's why I'm against this bill. I urge and I'm favorable on it. And as I offered in the previous bill,
McAvoy.
Thank you. When we're having these issues with young children, and I see them and I talk to them, the issue of family must be addressed. So if we focus that in the core and the central, you'll get to the core of this issue. Thank you for your time, committee. Have a good night.
Delegate Conaway.
Thank you, Mr. Chairman. Thank you, Mr. McAvoy, for coming in to testify.
Thank you, Delegate.
My question is this: since ignorance is no excuse for the law, when are we going to start teaching these juvenile and people who are in question what the law is? For example, if you're driving and you don't have your shoulder belt on, and you don't know that that's a part of your safety equipment, and I understand that's not a preliminary reason to stop, but you get pulled over because you didn't have that belt on, and you say, well, you didn't know. I mean, it was a valid stop. It's a valid reason to do that. When are we going to start to train and teach the juveniles what you can and cannot do, when you can and cannot jaywalk across the street?
Yes, completely agree. And this is where it gets to when they're talking, Delegate, you're exactly right. When they're talking about issues that involve the children haven't developed their mind and they're not culpable, this issue is because it's not being given down to them. So how do we do that? I mean, I wish we spent I wish we spent as much on the.
You teach it in school. I've been talking about something
Okay.
that's called the collateral.
I was going to go with parenting, but okay.
Yeah, I was going. No, it's something it's a little law book, collateral damages of criminal behavior that you can teach in the 6th or 7th grade that will teach a child you're supposed to go up to the corner and then go across the street, even if the store is right across the street. There are certain rules and regulations. If not, you put yourself in a position where you can be stopped and frisked, where you do look suspicious, where you're not following the law. And that is one of the problems. There's a disconnect between the education, what is being taught, and what we know. So when you're confronted with something that makes no sense, why do you have to stop your car just because it's a stop sign and there are no cars there? You can see it's no cars. You just cruise on through the stop signs because the stop signs say stop. But now you've created a violation. See, that has to be explained to you. It's not that you don't understand, it just needs to be explained. Would you like to comment on that?
I would, Delegate, and it's interesting that you brought up traffic rules, because as you look at the body of law and the things that you all look at all the time, what do we so rarely have to change? The traffic laws. And why? I want to go to the point of engineering best practices, morality, and ethics. When we look at that as a composite, and we look at, and this is something I tell the elders in our city all the time, share what you know. If they don't hear it from you, they're not going to get it because they're toned out, they're not listening. If they listen, and I tell this to elders all the time, share what you know so that they can take it and carry it to the next generation. We had the benefit of that. If they don't, we need to get it in there somehow. So what you're saying, spot on.
Thank you very much.
Delegate Cham.
Thank you, Chairman. Mr. McAvoy, I believe, am I saying that
You
correctly?
did, Delegate Cham. Thank you so much.
Okay, thank you. Are you aware of any data that exists that speak to children, African-American youth who have engaged or committed certain crimes that we're speaking of in this bill, and family dynamics? If there's a father in the home, are parents, the parents divorced, if the child was raised by their grandparents, or things of that nature, those factors, are there any data that exists that might speak to that?
Thank you so much for the question, Delegate. I'm going to forward that to you. I'm going to copy the rest of the committee. When I was with National Parents Organization, we had an incredible writer. He's so much more prolific and more succinct than I am. He's a great guy, Don Hubin. And he's an incredible writer, been writing for National Parents Organization for probably 20 years, even at the appellate level. And I will get some of his best stuff to you that's succinct, doesn't take you all day, because that data does exist, yes.
Thank you.
Further questions? All right, seeing none, that concludes the testimony for the bill, concludes the testimony for the House Judiciary Committee today. We will be meeting next on for a voting session tomorrow. I believe we've set it at 2:30 p.m. tomorrow. We'll have another day, perhaps not a long day, but a period of testimony on Monday, the 14th from at 10 o'clock. So we'll be hearing testimony again then. Thank you all very